Morning. Welcome back, commissioners, to our second day of hearing this week. I believe that we start off with a roll call this morning.
Do we do roll call first or come out of executive session first?
Well, I was instructed to do the roll call first, then we come out of executive session.
Okie dokie. Chair Benton?
Present.
Vice Chair Boygan?
Here.
Vice Chair Holton? Commissioner Egger?
Here.
Commissioner Hawkins?
Here.
Commissioner Jolly?
He's here.
He's here. He's just stepped out for a moment.
Commissioner Overturf?
Here.
Commissioner Randall?
Here.
Commissioner Wolf? I have 7 of 9, Mr. Chair.
Okay. We got, you had a proxy. Mr. Davenport, we were in executive session.
That's correct. Thank you. We are returning from executive session. During executive session, the commission received legal advice pursuant to 246402-3A Roman 2 on the statutory requirements for spacing under 3460-116. Our initial motion covered 2 other topics that were set for discussion in executive session this morning. We only got to the single topic that I named. We did not discuss the other two topics. No decisions were made during executive session and no votes were taken. Chairman Benton, I invite you to encourage a motion to exit executive session.
I would encourage that motion that we exit executive session.
Amen.
Motion has been made by Commissioner Jolly,
Second.
seconded by Commissioner Hawkins. All in favor, say aye.
Aye.
Aye opposed, same sign. Motion carries. I think the record should reflect that Commissioner Holton has joined us, I believe. If you could please confirm that, Commissioner.
I am here.
Thank you very much. I believe the next item on our list is public comments. I believe we do have some elected officials today, since we have a total of, is it 8 people today?
Yes.
Okay.
Mr. Chair, that's correct. I have 8 people based on the online signups as well as the signups at the door this morning.
So we will hold to 3 minutes, but we'll allow the elected officials 5 minutes today. So with that, we will proceed.
Starting with the online sign-up sheet, the first 3 commenters are Boulder County Commissioner Elise Jones, Mayor Christine Berg from the City of Lafayette, and City of Lafayette City Councilor Jamie Hawkins.
Good morning, Commissioners. My name is Elise Jones, and I'm proud to be a Boulder County Commissioner, and I really appreciate the opportunity to testify before you today. Boulder County owns significant surface and mineral interests within 8 North drilling and spacing units. Moreover, thousands of county residents live in and near those areas. We understand that 8 North proposes to locate its wells in Weld County and within the town of Erie. However, we have plenty of evidence from area residents in Boulder County that the impacts of large-scale drilling are not confined to well pad locations. Noise, odor, light, and pollution do not respect approved sites or jurisdictional boundaries. Our volunteer inspection, in fact, I should say that just yesterday I got a complaint from a Boulder County resident about noise coming across the Weld County line. So it's quite frequent that we hear about these cross-jurisdictional impacts. And our voluntary inspection program has revealed that oil and gas facilities leak despite best efforts. As you may recall, and as you'll hear more later today, our inspector found that gas leaks occurred at 65% of inspected sites at Boulder County, 65%. Methane and other VOCs from oil and gas development, as you know, are major ozone precursors. Our region has not yet been able to come into attainment with the 2008 National Ozone Standard, and we're going to have an even much harder time coming into compliance with the new, more stringent 2015 standard. And as a member of the Regional Air Quality Council for the past decade, I can assure you that there's no way we're going to meet the new standard without curbing growth in oil and gas emissions. We just can't find those emission reductions anywhere else. Methane is also a potent contributor to climate change. We're in the middle of a global heat wave. 17 of the hottest years on record have occurred in the last 18 years. And as you know, there are rampant wildfires raging across the country. As of yesterday, 13 in Colorado and 98 nationally are burning right now. So I would hope that we no longer need to debate the existence and the urgencies of climate change. Our air quality monitoring partnerships with the University of Colorado and other institutions demonstrate that VOCs from oil and gas travel with prevailing winds, meaning that VOC leaks, including BTEX and methane, leaks from Weld County affect the air quality in Boulder County. For all of these reasons, Boulder County is an intervener in the 8 North applications, and we ask the Commission to carefully consider the evidence and legal arguments that we're going to present today. In particular, one issue I want to call your attention to is the evidence that you accept from 8 North to support its right to the development it proposes. When a landowner comes to the county with a proposal to develop property, we require the applicant to provide competent evidence of foundational questions like the applicant's property ownership and proof of access to the property. The units that 8 North seeks to establish carry heavy consequences for affected landowners, neighbors, the environment. Yet I understand that it's the long-standing practice of the commissioner to simply take the operator's word that the operator owns the requisite mineral interests. I'm not an attorney, but that just doesn't sound right to me. Seems that a company seeking to profit off of the minerals under another person's land should be required to make a good showing of its basic right to do that. And I hope you take our attorney's arguments on this issue very seriously. So in closing, you've heard from me before, you're going to hear from me again. The status quo of oil and gas development on the Front Range and the trend towards larger and larger facilities occurring closer and closer to more populated areas simply does not work. Boulder County, along with its sister governments, will persist in pressing for better protections for our constituents in this proceeding and any to come. Thank you again.
Thank you, ma'am.
Mayor Berg.
Here, just got here. Exciting. I actually have a letter from 25 local electeds. Who shall I give it to hand out to all of you? Okay. It's not stapled, my apologies. Here you go. I think that's accurate.
Welcome.
Good morning. Thank you for the opportunity to speak today. My name is Christine Berg. I am the mayor of Lafayette. I want the members of the commission to know that I've spent more time on oil and gas extraction in my 7 years on city council than any other issue. Think about that. I spend most of my time as mayor on oil and gas extraction, a heavy industrial activity that will greatly impact my citizens, their health, home values, and quality of life that I have virtually no jurisdiction over. This, of course, includes 8 North's application to drill 20 wells right on the border of my community. I should be spending my time creating policy, managing the budget, and determining the future direction of my city. Antiquated rulemaking for a bygone extraction era is an affront to my ability as a mayor. As a parent, it means I can't protect the health and safety of my own kids. We are home rule municipalities for a reason, to make the best decisions based on the values, economic impact, and vision of our community. Current law and regulatory mandates makes this currently impossible. Even though these wells are placed just outside of Lafayette city limits, we will encounter increased industrial traffic, impacted air quality, and everything else that goes along with this heavy industrial activity. Based on living near one of the most fracked counties in America, I'm deeply concerned about the unknown long-term and cumulative health impacts of the encroachment of oil and gas near our homes, schools, and hospitals, particularly on the most vulnerable, that being the developing lungs and bodies of our children. So today I brought you a wonderful letter from 25 local electeds. The gist of it is that we are joining together to send you this letter to yourselves, the commission, as well as Governor Hickenlooper, because we are concerned about protecting the health, welfare, and safety of our Colorado citizens. With the rapidly increasing residential oil and gas development encroaching in all of our communities, we have recognized that the industry is creating border wars between neighboring municipalities. One example that supports this statement is how oil and gas operator proposals continuously attempt or successfully move well pads out of one jurisdiction into another. We are writing to inform you, and I'm here to tell you today in person, that we will continue to stand united against these border wars and not be swayed by this divisive approach. We insist that the state uphold and enforce the Colorado Oil and Gas Conservation Act, which states that it is declared to be in the public interest when oil and gas development is done, and I quote, in a manner consistent with the protection of public health, safety, and welfare, including the protection of the environment and wildlife resources. We as a collective local elected body strongly urge a paradigm shift in how large-scale oil and gas developed, and we believe that shift warrants an updated set of regulations. Multi-well megapads do not belong near our homes, schools, and water sources. The current COGCC rules, again, are antiquated, arbitrary, and address the regulations that were literally set up decades, if not half a century ago. That is signed by electeds from 3 counties, and commissioners as well. In sum, I'm here today instead of being with my 5-year-old and my 1-year-old because it's so important to me not just as a parent, but as an elected official, that I have the opportunity to speak on behalf of the 28,000 citizens that live in my community, but in a broader sense. These large mega sites, the cumulative impact is unknown. As they get closer, as they get larger, we are very, very not just concerned. There's a lot of fear in my community. And as you may have heard, there are lots of folks that have come to our city council meetings and have expressed concerns because they feel powerless. And so do we as local electeds to address these issues. So I come here today knowing that those up to 20 wells for 8 North, they may be on the border of my city, but they are near one of our largest employers, Exempla Hospital. They are near our schools, and they certainly will impact my constituency regardless of where these are placed. Thank you so much for your time today.
Thank you, ma'am.
City Councilor Jamie Harkins.
She's not here at the moment.
Okay, thank you.
Let us know if she does come, and hopefully she can speak if she shows up in time.
Mr. Chair, that concludes my list of elected officials who are here to comment today.
All right, can we move on?
Kate Christensen, Cindy Lurie, and Sonia Wakiz Lewis.
Hi, my name is Kate Christensen. Thanks for allowing me the opportunity to speak today. Cindy Lurie, I got an email from her. She had to attend a funeral today, so she will not be present. I'm a resident of Lafayette. I'm a mother of 2 young kids, and I'm the co-founder of Together Against Neighborhood Drilling, which is a group that delivered over 200 postcards to the COGCC to Matt Lepore back when he was then commissioner back in January to protest 8 North's potential drilling near Lafayette. Most of those postcards dealt with the health, safety, environmental impacts of drilling, which I'm sure you've heard a lot about yesterday. We'll hear a lot about today. So I'm not going to talk about that. I'm going to talk about money, because it seems like that's what this is really about. Oil and gas wanting to access their property under our homes, schools, and open spaces. So if that's the case, we need a cost-benefit analysis of what this is truly costing our communities. There's a wide body of research that shows increased risk of asthma, birth defects, low birth weight, and cancer when people live near oil and gas drilling. How much does it cost a family emergency room visit for a kid who's having an asthma attack caused by this drilling? We need to have a moratorium on these until we figure out how much this is costing our communities. And we need a medical fund that oil and gas pays into, because we're only talking about how much they profit. We're not talking about how much they cost us. There's another body of research that shows reduced home values when we're near oil and gas sites. My home is our family's investment. I mean, we're not rolling in the dough. So if we're losing money on that investment because of oil and gas drilling, I want my money back. I want oil and gas to be held liable for that. I've been a Boulder County taxpayer for 20 years. If they drill my open space that I've been paying into for 20 years, that I walk my dog on every day, I want my money back. I think oil and gas should be held liable for this. Hickenlooper has made some small steps in taking care of orphaned wells. We have 50,000 wells going in our state. I don't want my grandkids to be paying for these abandoned wells once the LLC dissolves, once 8 North dissolves after they've taken all their profits. And we have to do the cleanup. That's been the history of mineral extraction in our state forever. The coal companies go away and the coal mine leaks, and we clean it up later. And that shouldn't be anymore. I want oil and gas, since they're making the big bucks, to pay for all of it. The Denver Post reported that the COGCC is going broke because oil and gas is getting so many tax refunds. So, I mean, if our severance tax was like Wyoming's, thank you. If our severance tax was like Wyoming's and we were paying for college for kids, that might be a different story. But we're paying oil and gas from our general fund, which should be going to my kids' school so they can make kids sick next to their schools. And that is not right. I want oil and gas to be paying us for everything they're taking from us. Thank you.
Thank you, ma'am.
Is Ms. Lewis here? right, that concludes our online signups then. Signed up this morning, I have on the list in order Andrew J. O'Connor, Mary E. Henry, and Marie Adams.
Good morning. My name is Andrew J. O'Connor, and I'm from Lafayette, and I'm the co-sponsor of Ballot Initiative 94, Severance Tax on Oil and Gas. Currently, in Colorado, oil and gas pays 0.6% in severance tax, which is the lowest in the United States. This ballot initiative would significantly increase the revenue to you, the Colorado Oil and Gas Conservation Commission. But I'm here now to talk about this 8 North LLC application. So please find our request for you to deny 8 North LLC application for drilling and spacing units in Boulder County. There are 319,372 people that live in Boulder County, and these applications represent an existential threat to our health, safety, welfare, and environment. Several peer-reviewed medical studies have demonstrated that people living within 7 miles of fracking sites experience skyrocketing cases of asthma, diabetes, cancer, immune system diseases, cognitive deficiencies, miscarriages, and birth defects. In fact, women in Will County suffer 200% more miscarriages than women in Boulder County. You have a 7 times more chance of getting leukemia if you live in Will County than if you live in Boulder County. Hydraulic fracking companies in Colorado release into the air and inject into the ground solutions containing known carcinogens or volatile organic compounds which endanger our health. Fracking results in air, water, and soil contamination, species extinction, ozone depletion, climate change, and necessitates medical treatment for the asthma, cancer, immune system diseases, and cognitive deficiency and miscarriages and birth defects that I just talked about. So while the profits from fracking go to the oil and drilling companies, the cost of cleanup, adverse environmental and health consequences will be borne by the people of Lafayette and Boulder County. The oil and gas companies are putting their profits ahead of the health of the people in Colorado and Boulder County. Consequently, we are asking you to do your job and put the health, safety, welfare of the people and environment before the profit of oil and gas. As you know, 2 people were incinerated last year in Firestone because of fracking negligence. Is that it? Based on the foregoing, please deny 8 North LLC's application for drilling and spacing units in Boulder County. Thank you very much.
Thank you.
Hi, my name is Marie Adams. I'm from Boulder. I'm here today to talk and ask you to take a couple of reports under advisement and deny the permits for the 8 North wells. I spent the last 15 years of my working career in Colorado. 2009, I retired. And that year, I noticed as I drove across the state, the increase in gas wells going up. When I left the state, I knew that it was impending that this industry was going to start taking advantage of the shale foundations here. And I was dismayed at that point. When I returned in 2014, I was amazed at how the landscape had changed. And I did the best I could to educate myself and inform myself on the impact of fracking. And I have, in 2014, NASA did a study and identifying the hot spots for methane release. At that time, I was shocked to find out globally, Colorado was on that list. Since then, NASA has done a study in conjunction with NCAR and a university in the Netherlands, and it identified methane gas as the leading contributor, not agriculture, not wetlands, but oil and gas release. So I didn't bring this study, but I brought an article that you can research on that. The other study that I found to be incredibly informative was done by the Maryland Department of Public Health and Safety. It studied every aspect of hydraulic fracking, the implications on health, the environment, and the climate. I didn't, once again, print out the report. It's 203 pages. It is the most comprehensive report that I have seen in the 5 years that I've been looking at this subject. So I would like you, I'm going to turn these in and consider them really seriously, because these people are the best and brightest minds in the country at Nassau and from Johns Hopkins University, which is a world-renowned and medical facility. And those are the people that wrote these and researched these reports. Thank you for your time. And I appreciate that you gave me the opportunity to speak today. As a grandmother of 5, I don't do this. And I didn't think I'd be doing this during my retirement years.
Thank you, ma'am.
Hello. My name is Mary Henry. I'm from Lafayette. I'm a co-sponsor of ballot initiative 94, which is a severance tax on oil and gas. Thank you for giving me the opportunity to speak before you today. I'm here today on behalf of the citizens of East Boulder County and Lafayette to request that you deny North 8's request for permits to drill in Boulder County. In the last few years, we have seen more peer-reviewed medical research proving there are significant health impacts associated with living within 7 miles of a fracking operation. Residents living close to wells have higher levels of benzene and ethylbenzene in their blood. A study released recently proves methane is leaked from such wells at greater levels than the EPA even reports. Because of this, it is time for the state of Colorado to stop putting profits over residents' health, over our children's health, and over our environment. It is time for the COGCC to do the job it was created to do, which is to protect the residents of Colorado. Thank you very much for denying these permits.
Thank you, ma'am.
City Councilor Jamie Harkins, are you here? Sonia Waquez Lewis, are you here? All right, Mr. Chair, that concludes, or that's everyone on the sign-up sheet.
Is there anyone else that's not signed up that would like to have a word? Very well.
Yes.
All right.
Just sit right here.
Good morning. I'm Gina Simpson Lee, and I live in Boulder County. I've lived in the area for 47 years now and seen a lot of changes come down. The main thing I wanted to talk about was that we make plans years ahead, and our future is so uncertain, especially concerning energy sources. Extracting energy from these sources and storage or transportation of this energy. Climate change is happening, and our choices may immensely change in the next 5 or 10 years that we're all planning for here. Either we're part of the problem or we're part of the solution. When renewable energy storage becomes a viable alternative to non-renewable energy, the non-renewable dependent systems will have to switch to new sources and utilization rather than extraction of these resources. Of course, in the meantime, we are hopelessly dependent on petroleum, and the transition will be gradual because we still need these things right now and will for quite a while before this transition is fully made. Especially concerning jobs, equipment, production, and damage control. All these have to be taken into consideration. Thank you very much. That's pretty much it.
Thank you, ma'am. Wonder if we take a break. All right. Commissioners, it's all right with you. I'd like to take a brief break since we started this morning a little earlier. And then we'll come back and start with the consent agenda matter. Oh, 10 minutes.
Thank you.
Consent agenda matter?
Yes, Mr. Chair. Let the record reflect, we are an hour and 20 minutes ahead of schedule. So,
You just
unprecedented.
jinxed us, you realize that.
I may have. It's like a no-hitter the minute you mention it. The next items up are docket number 1710-00694, 1712-00773, 1710-00695, and 1712-00774. The first matter is part of your consent agenda. The other three matters have a protest, and Hearing Officer Rouse has introductory remarks for you.
Okay, so are we? Or perhaps, Ms. Bryant, do we separate the consent matter from the balance? Which would be my understanding. So we
Yes.
Hear that, and thank you,
Yes.
Mr. Rouse. So would you like to elaborate on the first item on there? 171-000-694.
Yes, docket number 1710-00694 involves the creation of a 1,280-acre drilling and spacing unit for the Niobrara and Codell formations in Boulder County. Originally, the applicant 8 North sought approval for 20 horizontal wells. The application was then amended to request only one well. So that's what's before you today, is the establishment of the drilling and spacing unit with approval of one well. Boulder County and the town of Lafayette filed a protest, as did the town of Erie. 8 North filed a motion to dismiss the protest on the grounds that the protest did not meet the Warren standard for pleading, and that issues of public health, safety, and welfare are not relevant considerations in a spacing case. Boulder County and the town of Lafayette filed a response, and 8 North filed a reply. The hearing officer entered an order granting the motion to dismiss the protest of Boulder County and the town of Lafayette. No exception was filed pursuant to the State Administrative Procedures Act. 8 North and the town of Erie reached a settlement, and the town of Erie protest was withdrawn. The protests have been dealt with. This matter, or since the protests have been dealt with, this matter ordinarily would have been placed on the consent agenda as a whole. However, it was the hearing officer's understanding that the commissioners wanted to consider all 8 North Boulder County matters at one time. Also, the hearing on the rest of the consent agenda is tomorrow, and this drilling and spacing unit must be approved prior to your approving additional wells requested by the application in docket number 1712-00773, which is to be heard by you later today. You may approve the application and draft order in docket number 1710-00694 based upon the hearing officer's recommendation, just like you would any other consent agenda matter. Or if you are inclined to spend the time, 8 North is prepared to present evidence in support of its case if the commission so desires. However, basically the same evidence will be presented when you hear the other 3 cases later today. So that is the reason for having a separate little consent agenda item before we start the other hearings.
All right. Let me ask, any conflicts of interest with this matter? No, we'll ask that for this and the general hearing matters coming forward from 8 North as well.
I'll just repeat what I've said before about extraction and its affiliates. I have in the past done work for extraction. I am now actively adverse to extraction on several matters. I think I can still be impartial in any matter in which they are a party, but if the commission or if the parties think I should recuse myself, then I would give that serious consideration.
Concern for the commissioners? Hearing none. Concern for the parties?
No objection from 8 North, which is a subsidiary of Extraction Oil and Gas.
Okay. We'll ask when we get to the next ones. We'll check with the Boulder County folks as well and as well. I notice on here that there's a 510 statement. Is that something that has been embedded into the record, or do we want to hear that?
There was a 510 statement filed by Sierra Club in all of the 4 cases, and that has been provided to you in the portfolio. I am not aware the Sierra Club is present and wants to make a statement, so you've got it.
Yeah, I'm aware of all. There's a significant amount of material in the records.
Yeah, it's like 3,000 pages.
Yes. So it'd take forever to read that, but I don't know, is there someone from Sierra Club who would like to make a brief statement? We'll give you that opportunity. Hearing none. At this point, and I believe you mentioned that the evidence for this will be presented in the subsequent general hearings.
It should be the same evidence, basically, because docket 1712-00773 is the additional wells application on which there will be presented evidence, and it should be the same evidence.
Commissioners, would there be any reason why you would want to hear that at this time? No? Hearing none, I believe we could proceed, since it's a consent matter, with a motion to approve this application.
So moved.
A motion has been made to approve docket number 171000694, application for an order to establish a 1,280 acre drilling and spacing unit for the production of oil and gas and authorize the drilling of one horizontal well within the proposed unit. Is there a second?
Second.
Seconded by Commissioner Holton. Any discussion? All in favor, please signify by saying aye.
Aye.
Opposed, same
Aye.
sign. Motion carries. All right. So we're on to the next items. Mr. Roush, if you'd like to introduce those.
Not really, but I will give it a shot here. And if I leave something out, I'm sure the able counsel for one of the parties or the other will remind me of it. These are three cases involving 8 North applications in Boulder County. We've decided to go ahead and combine the hearing on them for hearing purposes because they should involve similar geology, similar engineering, and the arguments of the protestants are basically the same in all three cases. You will, however, need to make separate findings on each case and a separate ruling on each case so we can have separate orders that we usually need. Docket number 1712-00773 is, as I stated earlier, the additional wells application that goes with the prior spacing application that you just approved. It's a request to authorize up to 20 wells within the unit. Boulder County and the city of Lafayette filed a protest to this matter, as did the town of Erie. The town of Erie protest has been settled and is no longer before you. We do have the protest for Boulder County was dismissed upon a motion to dismiss by the applicant. There was an exception filed to that particular order. Subsequently, to cut the procedural things down to size here, the 8 North and Boulder County agreed that Boulder County could file an amended protest. They further agreed that 8 North would not move to dismiss the amended protest, and that Boulder County and Lafayette, when I say Boulder County, I'm talking about Boulder County and Lafayette since they joined in the same pleadings in this case. Anyway, Boulder County and Lafayette agreed to withdraw their exceptions. So it is the amended protest and the amended application, or the application that are before you today. Subsequent to the pre-hearing conference in this matter, the town of Lafayette and Boulder County entered into a stipulation regarding language to be included in the order, and I'll pass that language around to you now. This language deals with the location of the well, and you will probably want to consult with your legal counsel regarding whether or not you want to make some tweaks to that language like you did in the Broomfield extraction cases that also had stipulated language regarding the location of pads. Shifting over to the other two cases for just a moment here. The docket number 1710-00695 is an application by 8 North to establish an approximate 2,720 acre drilling and spacing unit for certain lands in Boulder County and authorize or approve the drilling of one well in the drilling and spacing unit. The companion case to that is 1712-00774, which is the additional wells case, which seeks to have an additional 31 wells approved in the drilling and spacing unit that's being sought by 1710-00695. Again, the procedural history regarding the protest is the same. However, in these cases, the city of Longmont was also involved. They filed a protest. They entered into an agreement with 8 North regarding language in the order, which I will pass out to you now. Again, it has to do with pads and the location of the pads. And again, you probably will want to consult with your legal counsel about that language. So the city of Longmont is no longer a participant in this case, but the city and county of Boulder remains in these two cases. I also believe that Crestone Peak filed a protest in these cases. The protest was withdrawn and Crestone Peak filed a 510 statement in support of the applications. That 510 statement has been provided to you in your portfolio, as has another copy of the Sierra Club 510 statement, which was filed in all 4 of the cases. Pre-hearing statements were filed. The parties objected to each other's pre-hearing statements on various grounds. Motions in limine were filed. The motions in limine were ruled on at the final pre-hearing conference. Boulder County and in the 773 case, Lafayette, have elected to file an exception to one of my rulings on a motion in limine that deals with the, let me get this right here. It's the ability of 8 North to introduce oral and demonstrative evidence regarding their ownership in the application lands in all of these applications. And I will let the parties explain what their positions are, but basically 8 North wants to use the kind of summary testimony, we own however much percent and leases like we always do in all our cases. And Boulder County and Lafayette believe they should have to prove that and bring forth leases and change of title and that sort of thing. And I ruled against that motion in limine, and that's what's before you today. You will need to consider the motion in limine first before you take any of these cases. You've already determined that nobody has a conflict of interest that anybody objects to. So there will be 10 minutes of oral argument for each side, and then you will need to decide whether to uphold the hearing officer's ruling. If you do that, the parties are ready to proceed with the 3 cases. If you elect to reverse the hearing officer's order on the motion in limine, I think you can still proceed, but 8 North will probably not be able to prove part of their case that they have to prove to get their applications approved. So I think that's where we're at on that. Assuming the cases go forward, each side has 90 minutes to present their case. That's opening, closing, cross-examination, direct examination. Those times are exclusive of commissioner questions and answers to those questions. So with that, I'm going to dump this mess over in your lap, Mr. Chairman.
Thanks, I appreciate that. Right. Okay. So for these matters that we've confirmed it with 8 North representatives that no concern about conflict of interest for Commissioner Boygan, but we need to confirm that with Boulder.
No objections from Boulder County.
All right, thank you very much. Um,
No
Yes.
objections from the city of Lafayette.
Oh, I'm sorry. I apologize for that. I did have a question. I noticed in the just for clarification, there's two final pre-hearing orders. Both of them are fairly much the same. Is it 90 minutes cumulative for all these matters?
Yes,
per party?
all three matters are being presented jointly, and it's 90 minutes for all three matters per side.
All right, just wanted to clarify that.
Yeah, they don't get 2 bites at the time.
Okay, thank you very much. So my understanding and instructions is that we need to hear the arguments for the exception to the motion in limine next.
That would be correct unless your counsel advises you otherwise.
Sounds right to me.
All right. No particular order of proceeding, I guess.
Well, it would be Boulder County Lafayette
That's
going
what-
first, since
that's
they're
what
the
I
ones
just
that
thought.
filed the exception, and this is strictly oral argument.
Right, and that was my guess at that, but thank you for the clarification. So let Boulder County and Lafayette go first.
Yeah, and just to clarify for the record, this is Jeff Robbins, this outside counsel for the city of Lafayette. As the hearing officer mentioned, the city did reach a stipulation, and it's just between the city and 8 North. And the language was presented to you. It has to do with surface location. If that language is incorporated into the ultimate order here, then the city is not going to present its evidence and testimony, nor will it cross-examine witnesses at this point in time. The city still supports the procedural arguments that Boulder County is making, and otherwise we'll sit back and let Boulder County make those arguments.
Morning, Commissioners.
Just a minute, Mr. Chairman, I think I misspoke on the timing. When they go to present their cases, the parties have agreed that 8 North has 90 minutes and the protestants have 60 minutes to present their case.
That's okay. I was going to let that slide because it was you have it.
Well, you certainly have that prerogative, but I have been reminded that it's
No, I
90,
was going to
60.
stick with the 60 minutes, but I just didn't want to bring that up. So, all right, do we need to go ahead? Sorry.
Okay, Kate Burke, Assistant County Attorney for Boulder County. And just to clarify, I think at one point Mr. Rouse mentioned the city of Boulder. The city of Boulder is not a party here. It's simply the county.
Boulder County, yes.
And then the city of Lafayette. And as far as the exception and the evidentiary issue, that does apply to all of the 3 dockets where Boulder County is a party. So I'll make one argument, but it does apply to all 3. And I was going to rely on the fact that you had it in your portfolio, but I'm understanding how large the portfolio is. I'll try very hard to summarize briefly. The issue here is whether the best evidence rule must apply basically in agency proceedings. And the best evidence rule says if you're going to prove the contents of a written document, that actual written document has to be brought into evidence. The exception to that is the summary evidence rule, which says if you have voluminous written documents, you may present a summary of them rather than the actual documents. However, in order to do that, there's a 4-prong test that has to be met. And that's put forth in the U.S. Welding case. It's cited in our exception that you have, if you want to look at that. And there are 4 parts to the test. The county and the city are not contesting 2 of the parts. There are really just 2 parts of that 4-part test that we're concerned about in this instance. Those 2 parts are the proponent of the summary evidence, and in this case, we're talking about 8 North's Exhibit 1, and it's the testimony of its landman that would summarize, we own 54% of the leases, and summarize it and show you a map of where their leaseholds are without the actual lease documents. So the 2 parts of the test that we argue 8 North has not met are they have not identified what the underlying documents are and shown that they are actually voluminous. And the second part is they have not provided the county or the city with the opportunity to inspect those underlying documents in a reasonable place and time before the hearing. Now, I need to say last night at about 5:45 and then later at after 11 p.m., Counsel for 8 North did email us a single lease so that we have 2 different units, than what we call the northern and southern units. They emailed us a single lease in each unit, and then a chain of assignments of that lease changing hands up through 8 North. So I think they're going to say that they've now satisfied what the county has asked for. So I need to clarify some of the statements in our exception. That doesn't satisfy the test because of several reasons. First of all, we're presuming, when we'll find out shortly, that they will still want to offer their summary exhibit. And so providing us with one of the leases under that goes into that summary does not meet the US welding test, first of all. Second of all, the element of providing to the party with a reasonable time to inspect is a key part of that test. And it's the key issue in several cases. I'll just quickly reel these off. The Airborne case, 832 P. 2nd, 1086. The Metro National Bank case, 773 P. 2nd, 633. The Murray case, 374 P. 3rd, 443. International Technical Instruments, 678 P. 2nd, 558. And US Welding, 261 P. 3rd, 513. All of those turned in large part on whether the documents were provided a reasonable time before trial for inspection. And I'd submit that 11 p.m. the night before is not a reasonable time. So they're insufficient to cover the actual summary evidence, and the time was not provided for us to inspect them. So, and then the other point I just want to point out, we mentioned in our exception request that one way to look at this evidentiary issue is that we don't particularly agree with this standard, but in many instances, an applicant only has to show that it's an owner. It does not have to show that it's an X% owner in a certain area. And so if you agree with us that you as the commission need to take best evidence and not just unsupported summary evidence, that immediately leads to a problem of how can we spend our time, your time, looking at what could be piles upon piles of leases and assignments and conveyances. And so we made the suggestion on the side that if that's something that you feel is important, you have the option of requiring them to prove up one bit of ownership in a unit. We personally think that's insufficient, but you could potentially go there if you're persuaded by our argument that best evidence is important. However, that's not really relevant to this proceeding today, where we oppose their exhibit. They actually have 2 exhibit 1s, one for each unit, because those summarize, I think, 54%, and I think, I don't know, another percentage, 70-something% in the other one, you'll get that. But they summarize a great deal of information. And so their having supplied us with the one lease late last night does not satisfy the issue here today. And then there's one other point I wanted to raise yesterday. I was very interested to hear Mr. Rouse say that in the 8 disputed pooling applications that you heard yesterday, one of the reasons that he went ahead and continued that is he found 8 North was not ready for the trial on those matters, and in part because they supplied summary lease evidence in that case where they did not give the other side the chance to look at the underlying documents. And so in that instance, he found that to be a significant issue, whereas here, where we're talking about they're proving the most threshold piece of their case, the relief they want, he ruled rather that your practice of having accepted summaries all along was enough to deny our argument. So I'm going to leave it at that and see if you have any questions for me. I don't know if I have any time left. But.
And it's 45 seconds.
Oh, perfect. We'll use that for rebuttal.
Commissioners, any questions? Commissioner Boygan.
Thank you, Mr. Chair. Ms. Burke, can I just ask you, is it your position that the applicant is required to prove up its title to every lease that it claims ownership to inside the proposed unit, or is it sufficient for an applicant to establish that it is an owner of any interest within the proposed unit?
Well, I guess I hear 2 different questions. One, in my opinion, is kind of a policy question of what we think would be the best practice. The other one is how rules and statutes are written now. Currently, for I think virtually all of the different kinds of permits and relief they can request, they only have to be an owner. And so
that's in the rule, correct?
Yes, and I think in the statute
says interested party.
Okay, thank you. Thank you for that clarification. So, so the way the rule is written now, I'm offering you an opportunity to both address the best evidence rule without burying yourselves in arcane paper by saying that an applicant could prove a single leasehold. That's not what we think is the wisest course going forward, or for a variety of other reasons. But I think that is what it says today. However, again, I don't think that applies in these particular applications because of the proffered evidence.
Okay, thank you. That's responsive. Can I ask one more question?
Yes, you may.
What, in your view, would be required in order for an applicant to establish that it is an owner?
Well, what I propose, I think that I might have put this in my draft order for you, because again, I understand what it would mean for the commission to say, you now need to prove, as Mr. Parrott put it in the pre-hearing conference, from patent to present, every single, you need to absolutely prove the complete ownership, and that's probably unworkable. And so what I think you could do would be something like, say, what we need is the foundational lease itself and the assignments by which the current operator took those rights. And then if, for example, an opposing party said, you know what, I doubt that. I don't think that lease is any good. I have problems with that. Then they could raise that dispute, and then we have a back and forth to actually dig deeper and find out if the lease is still valid and look for further documents. But I think that you could meet the requirements of the best evidence rule with a fairly simple chain.
Thank you.
Okay,
May I ask a question?
you may. Commissioner Overturf.
Thank you. Let's take as a given that the commission has, as part of its past practice, regularly accepted this type of summary evidence. And your motion is to exclude all of that summary evidence. Even if that motion is not granted and we find that evidence can come in, that we relax the rules of evidence, would it be your position that would you nonetheless be raising an argument about the sufficiency of that summary evidence? That even though that evidence may be admissible, it is insufficient to prove the element of ownership?
Would we? That's a good question. So admissibility versus sufficiency. I think we probably would argue that there are sufficiency problems, particularly with the foundation for the landman to testify. Some of the cases go directly to that there's written summaries or depictions, and then there's oral summaries. And some of the cases go to a witness can't orally summarize things that they don't have personal familiarity with. So that would be, I guess that's really an admissibility issue still. I'm not sure.
Okay.
I think we'd have to take that as it came.
Okay, so let's say that the okay, I'll leave that there. I have a question for the hearing officer too. In your case management order, was there an established deadline for the proffering of evidence to opposing counsel?
Usually the exhibits and evidence are due by the time that the pre-hearing order is filed. They're supposed to file their exhibits with the pre-hearing order. That's what the case management order is required.
And when was the pre-hearing order due in this proceeding? If you know off the top of your head?
I don't, but it's usually 2 to 3 weeks ahead of the final pre-hearing conference. That gives time for all these things like responses and motions in limine and a pre-hearing conference.
Right, okay. Okay, that's all, thank you.
I have a question also for Mr. Roush. Wondering if you might please clarify for us. I believe it was extraction yesterday, not 8 North, as to why you continued those matters.
The 8 North matter is a Rule 530 proceeding. It's a pooling proceeding. It's not a spacing or additional wells case. In the pooling the cases, the argument has been made by the protestants that they were not offered fair and reasonable lease terms. 8 North countered with, here's what we gave everybody else. And the opposition was, how do we know? And we don't know where these leases are located and all that sort of thing. So they were required to produce the leases. They were not required to prove patent to lease type of thing with all those types of documents, but they had raised, dozens, if not a couple hundred leases without any evidence of why they were relevant. And the evidence in that case is you've got to look at the lease and see where it is and see what the terms are. And that's what Rule 530 requires. Here we were talking about a standing case. Basically, you have a right to file an application, and we have always accepted that on the basis of the summary evidence, unless there has been something to come forward and say, we've checked the records on your drilling and spacing unit, and we don't see that you own any interest in there. At that point in time, I think it's incumbent upon the applicant to then come forward with the types of documentation that show they have an interest somewhere in that unit.
How much of that is, and this may be a question for you or for Boulder County, that as far as the leases themselves, is that a public record where those are recorded documents with the county?
It's been a long time since I've done title work. My understanding now is that a lot of these leases are not recorded, that are simply a summary of the lease that is recorded.
All right.
I think it varies from operator to operator what the practice is. I've seen some recorded leases, I've seen some summaries produced.
Okay, thank you.
Can I add to that just briefly?
I'm sorry?
Can I add to that
Yes.
briefly? Mr. Parrott made that a point at the pre-hearing conference, and that the county, of which the clerk and recorder is a part, has these documents. But at the same hearing, he also argued the reason he can't identify or produce the documents is because they're too voluminous, they're too difficult to find. He has to, I'm not sure if he said this, I don't want to put words in his mouth, but we know that operators generally hire title experts to go and figure this out at great expense and for great amounts of time. So to say all of that and then at the same time say, oh, but the county can find them themselves, to me is a very unsatisfying argument.
So I just had a question, so I didn't propose that, but
Oh, sorry.
perhaps Mr. Parrott may be able to respond when he gives his summary here. So there are no further questions for Boulder. We'll move on to 8 North.
Well, thank you very much. Good morning, everybody. Thank you for your time this morning. I'm excited to see that we're still ahead of schedule, but I'll try to keep my comments brief anyways. So the first and most important point that 8 North needs to make this morning is that it is not relying on the Colorado Rules of Evidence Rule 1006 for admission of its summary testimony and its summary evidence. It is relying on Colorado Oil and Gas Conservation Commission Rule 519. And if I could summarize that rule for you real briefly, basically it says we don't have to abide by the strict terms of the Colorado Rules of Evidence. To give you the exact language, Rule 519 says the rules of evidence applicable before a trial court without a jury shall be applicable, providing that such rules may be relaxed, whereby so doing the ends of justice will be better served. It goes on to state that the commission may receive and consider evidence not admissible under the rules of evidence if the evidence possesses probative value commonly accepted by reasonable and prudent persons in the conduct of their affairs. Let me pause there for just a moment and go back to the hearing officer's order denying the motion in limine. And the hearing officer specifically found that the commission has relied on this exact sort of summary evidence in thousands of spacing unit cases and pooling cases. It is exactly the sort of testimony that the commission almost always relies upon in the context of spacing and increased density and pooling applications. I believe that's because the commission is composed of reasonable and prudent persons. And in thousands of cases, you all and your predecessors before you have, as reasonable and prudent persons, found that this type of evidence is the sort of evidence that will provide probative value. I'm going to talk a little bit later about the slippery slope that we would go down and the evidence that you would need to hear if you applied a strict application of Colorado Rule of Evidence 1006. But I'll just kind of put a pin in that for a moment and go on to the final part of Rule 519, which says, informality in any proceeding or in the manner of taking testimony shall not invalidate any commission order, decision, rule, or regulation. So if y'all find this morning that this evidence is admissible and deny the exception, your rules specifically state that the order that you enter today, whether it be for or against the spacing order, shall not be invalidated simply because you took summary evidence as to 8 North's working interest in the application lands. So that's the first and foremost point. We are asking you to rely on your own Rule 519 for admission of this evidence. This is the sort of evidence that administrative bodies rely on all the time because it simply is not possible for this commission, with the limited resources that it has, made up of 9 volunteers who, as Commissioner or Chairman Benton, I think, noted yesterday, are getting paid an average of less than 10 cents per document that they have to review, to expand the scope of their review by orders of magnitude. And I understand that Boulder is now just recently advocating for review of just one single lease. Let me make clear, up till about a week and a half ago, it was not advocating for just one single lease. It was advocating for chain of title for every single lease that Extraction has in the application lands. But even still, the amount of due diligence that goes into verifying the validity of one single lease is not only beyond the scope of this commission's resources, but, as I'll discuss in a minute, beyond the scope of the commission's authority. I want to talk for just a minute about the U.S. welding test case. This is Colorado Rule of Evidence 1006, the 4-part test that Boulder mentioned. The documents are available in the county records. The way that anybody wanting to verify ownership determines that a lease is valid, who owns the lease, is to start off with the county records and to go patent to present to confirm that when the United States granted the patent to the original patentee, that it was a valid grant. The next step is to chain the mineral ownership out to the point where you get to a lease. That can involve sometimes 2 or 3 conveyances. Sometimes it can involve dozens of conveyances. Many of those conveyances are subject to contractual interpretation about what a conveyance means. If y'all need to go verify that Extraction's lease or leases are valid, you have to start off with the patent to the United States, and then you have to make decisions about whether certain conveyancing documents did one thing or another, whether there was a problem with the conveyance that was rectified by a later document. It's basically what an oil and gas landman or an oil and gas title attorney does, and it does take time. And if Boulder wants to go verify that, it certainly has the right to do so. It has the records in its possession. It has them available. It can if it wants, but asking y'all to do that is going to be a very time-consuming process, even just for one lease. Boulder made the point that it had searched the records in the county and not found leases and assignments into 8 North. There are leases and assignments into 8 North. I think maybe I speculated at our pre-hearing conference that part of the problem was that Boulder was looking for documents based on what lands they applied to, but in Colorado, we don't index documents by lands. We index them by grantor and grantee, by name. And so that's how you have to look. In fact, these documents, they are recorded in the county. There are reception numbers that can be found. If you want to go grantor grantee, you will find the leases into 8 North. With that being said, to use Boulder's system, I want to talk a little bit about what that would entail for you guys as you process spacing applications, pooling applications. Boulder, in its exception, stated that it not only, in its email response when 8 North sent it some leases, it stated that it not only needs to see the leases, but needs proof that those leases are still held by production. So you're looking at a chain of title from patent to the lease, and then from the lease to present, and you're also having to go back and examine your own production records and make a determination that the lease is held by production. As you most likely know, that involves interpreting the lease, contractual interpretations to make sure that the lease is still valid. This is beyond the commission's authority and would put you in a situation where you spend almost all of your time just verifying lease validity. Not only that, but Boulder made this argument that it only needed to see one lease less than 2 weeks before the hearing. 8 North's responses to Boulder all along has been, you're asking for thousands of documents, tens of thousands of pages. We're not going to go through that exercise for what is supposed to be an efficient administrative proceeding. And then less than 2 weeks ago, Boulder did say that although they disagree with this standard, they would accept just that the applicant is required to only show that it is an owner in the application lands, not the entirety of its mineral position. So 8 North was in the position of, well, if it did that, Boulder still disagrees with that standard, and so it's probably going to file a lawsuit to say that's the wrong standard. But just purely out of a show of good faith, and in no way as an intent to satisfy Rule 1006, but just because 8 North thought it might be helpful to Boulder County, we did provide a lease in each unit and the chain of assignments into 8 North, thinking maybe we could avoid all this time this morning. I guess that's not going to be the case. Boulder still needs to see that those leases are HBP. They need to examine the validity of the lease. They need to examine the validity of the mineral ownership of the original lessor. So there's just a whole lot more that has to happen. So with that, I'd like to remind you that the hearing officer in this matter issued an order in favor of 8 North denying the motion in limine, specifically finding that we are supposed to be having efficient administrative proceedings. I think there was a lot of discussion yesterday among the commissioners about how important it is to back up the hearing officers and the hearing supervisors in these proceedings and before this tribunal. And absent some incredibly compelling reason, there's no reason to overturn the hearing officer. So with that, I would ask you to affirm the hearing officer's order. Thank you.
Thanks, Mr. Parrott. By the way, we're actually paid a little more than that. It's 21 cents a document.
Well, that's why you're making the big bucks, I guess.
I guess so. Any questions, commissioners? Very well. At this point, I believe you have 3 minutes left if you would like to say anything in addition. Does Mr. Parrott have any time left? Okay.
Sorry, I told you I'd be brief, and I guess I wasn't.
Use of your time, I guess. Go ahead.
Thank you. Yeah, just a couple points. One thing I just want to highlight here is the burden of proof issue. So, Mr. Parrott, as I mentioned before, explained to you how and why mineral title is so difficult to uncover. And so by saying Boulder County can go do that, essentially what that argument is saying is that the operator, would like to rely on my mineral rights to come on your property and potentially pool and develop your minerals, even against your will. But you, landowner, mineral owner, have to prove in some way that I don't have the right to do that. And that allocation of the burden of proof is just flies in the face of all basic principles of fairness. We put the burden of the proof on the party who seeks to gain something, who seeks to win a claim, defend against a claim, etc. We don't put it on the other party. The unwilling party who's been dragged into a transaction is not imposed the burden to do what Mr. Parrott just described. Boulder County is a large organization with a lot of staff. We could just as easily be an individual landowner, and we'd be in the same position. So I just want to point out the significant unfairness of that. The other thing I wanted to say about past commission practice, I have no idea, and I don't know that any of you do, but I very much wonder whether this issue has ever been raised. Has this summary evidence issue ever been challenged? So again, your acceptance of it in the past has been convenient and acceptable, but that doesn't necessarily mean that you've given it careful thought and decided it's the appropriate route in the past. We did not, in our email, ask for proof of production. We said we wanted time to inspect the leases. And for example, we might look at the proof of production records if we had time, but we weren't given that. Which leads to my next point. And again, this is sort of for your consideration if you take this into the future. I don't believe that what we're proposing puts you in the position of determining the validity of all those leases. And just as an example, when Boulder County takes in development applications, we take in the evidence, do you have legal access? Well, yes, here's my easement. The county doesn't evaluate the easement, check with all the parties and do an investigation. We are rely on a valid easement that's signed and recorded. And if the two parties to it have arguments, that's their thing to go figure out. When I would submit that you could take the same position, they've submitted the evidence we want, the leases, the assignments, they're recorded, they're signed. I don't see a problem with them. And then it becomes the opposing parties, if they think there's a dispute there, then they take on the burden of bringing counter evidence or whatever needs to happen there. Those are my primary points, so I think I'll leave it there.
Very well, commissioners, anything else? So I think what we have in front of us at this point is, I believe, would be a motion whether or not to uphold the denial or to deny upholding the denial. Commissioner Hawkins.
I think based on our historical practice of accepting summary evidence, I don't have a problem accepting the evidence that's going to be presented by 8 North. And I think our hearing officer's taken a hard look at that and made a good judgment and dismissed the objection, I guess. So I would make a motion that we support the hearing officers.
Would that be a motion to uphold the denial?
Uphold the dismissal of the
denial of the motion to eliminate.
Yes. Thank you for that.
Yes. Okay.
Yes.
Thank you, Commissioner Hawkins, for making that motion. Would there be a second?
I'll second it.
Seconded by Commissioner Boygan. Any discussion? Commissioner Overturf.
Thank you. I think there are a number of discrete issues here, and so I want to be really clear about what my position is. I think the issue in front of us is this motion in limine. It's essentially whether this evidence, this summary evidence, is admissible. And I agree with 8 North that under Rule 519 that evidence is admissible, that we can relax the standards of evidence, we can allow it into the proceeding. However, I am very compelled by Boulder County's arguments about whether that evidence is ultimately sufficient. And I think this goes to that issue of the burden of proof, that the applicant does ultimately bear the burden of proof in this proceeding. And summary evidence may be entirely acceptable, and we may feel comfortable relying on summary evidence where an application is unopposed, where no one questions the ownership. But where an opposing party raises the question of ownership, then I think the burden returns to the applicant to show, no, here's proof that I have ownership. I don't think it requires you to serve up every single lease and trace it back from the beginning of time, but I do think you need to show ownership in a single parcel in order to show that you've satisfied that requirement within our rules. So I will be voting in favor of the motion, but that does not mean, but I want to make very clear that I think the applicant still bears the burden of proof in light of the objections that have been raised by the protestants.
Very well. Commissioner
Mr.
Boygan.
Chair, I'll just comment briefly. The definition of owner in the regulations is the person who has the right to drill into and produce from a pool. Doesn't say the person who has good and marketable title. It just says the person who has the right to drill into and produce from. It's a pretty low standard. The statute itself only requires that an interested party file the application. So it's a minimal showing that has to be made, and I'm not actually disagreeing with Boulder in terms of burden of proof. I do think that the applicant bears the initial burden of introducing evidence that it is an owner. I think the summary evidence that we've long accepted is sufficient for that, but I think if it's challenged, I personally think that if it's challenged, the protestant or the party challenging it has the obligation to state a basis for the challenge rather than simply to say, I challenge your ownership. I want you to introduce even more stuff to prove up your right. I think there has to be some basis for challenging sufficiency, which is not present here. But I do think the hearing officer can make a determination in each of these matters if the question is raised about sufficiency, whether the summary evidence is enough. And so last year we had a proceeding where there was a question about ownership between two operators and whether the contractual right to drill that one party was asserting, in fact, gave that party a right that we were willing to recognize. And the staff had to come up with a process for sort of getting into that without, as Mr. Parrott put it, immersing us into actually interpreting contracts. It's not a clear line to draw. So there could be situations, and I will concede that, where ownership is an issue, in which case there may be other evidence that will have to be submitted. I think in a case like this, the summary evidence that's been offered has been evaluated and is adequate in accordance with our practice. So I support the motion.
Very well. Any further discussion? Shall we vote? Therefore, all in favor of the motion signify by saying aye.
Aye.
Commissioner Holton? May have lost him. All opposed, same sign.
Aye.
There we go. Okay. That's a motion. That's a vote in favor, I presume.
Yes.
Thank you. And opposed, same sign. The motion carries. Yes, Mr. Davenport.
Thank you. I just want to check with our hearings manager that the motion and the rule and the vote were clear.
Yes.
Okay, thank you.
Okay, so I think at this point, we're up to opening statements by the applicants. And to be clear, the applicant has 90 minutes, the protestants have 60 minutes, absent any questions by the commissioners.
That's correct. That's what the parties agreed to.
Okay. Was it clear on the record that Mr. Parrott provided, that James Parrott provided the discussion priorly on the motion in limine, that was Mr. Parrott speaking? I wasn't sure if he identified himself.
Mr. Chair, thank you very much for correcting that oversight. This is James Parrott representing the applicant 8 North LLC, and I was the person presenting arguments in favor of upholding the hearing officer's order denying the motion in limine.
Thank you.
Sorry about that.
No, that's quite all right.
Mr. Chair, are we ready to begin?
Ms. Fulcher.
Thank you. Good morning, Commissioners. Jill Fulcher with Beatty and Wozniak, representing 8 North LLC, which is a subsidiary of Extraction Oil and Gas. So from time to time today, you may hear us slip and say extraction. Please know the relationship. So there are 3 contested dockets before you today. They involve 2 distinct drilling and spacing units. The first unit to the north that you will hear evidence on is the blue paintbrush unit. That's what we're titling this. And this is, there are 2 dockets that are before you that have been filed with respect to the blue paintbrush unit. The first is an application to space that area as a 2,720 acre unit for production from the Codell and Niobrara formations. And then the second application filed with respect to those lands is an application for additional wells that was filed in docket ending in 774, where 8 North is asking for permission to drill up to 32 total horizontal wells in that 2,720 acre spacing unit, again, for production from Codell and Niobrara formations. The third unit at issue, we may from time to time refer to as the lupine unit. That's the unit to the south. That is the unit that you just approved by consent in docket 69, ending in 694. That established a 1,280 acre spacing unit for sections 35 and 36 in 1 North, 69 West. So the application before you now that's been contested has been filed in docket 773. That's an application to approve up to 20 wells in a 1,280 acre spacing unit for production from the Codell and Niobrara formations. I would argue that these applications are very similar to applications that are filed before you every month and that you routinely approve as part of the consent agenda and also under contested hearings rather. 8 North is asking for establishment of a spacing unit. So they're asking for you to establish a spacing for a given area for efficient and economic development. And in both applications or in both lands, we're asking for approval to drill additional wells so that we maximize resource recovery and prevent waste. So in my mind, the big distinction here is where these lands sit. They do sit in Boulder County, primarily in Boulder County. And that is an area that's gone largely undeveloped, at least from a horizontal perspective for some time. And as a result, Boulder County, as both a mineral owner and a local government, has protested these applications. I think that that's really the only distinction that we can come up with when we look at these applications versus others that regularly come before you. So before we get into the evidence that you will hear before you today, I want to remind everyone of the requirements that are enumerated under the Act in which you need to consider whether or not to approve drilling and spacing units and additional wells. And as you know, it is section 3460.116 of the revised statutes that empowers you to establish drilling units. And the legislature has empowered you to establish drilling units for a few reasons. 1, to prevent or assist in preventing waste, to avoid the drilling of unnecessary wells, or to protect correlative rights. Those are the same factors that are relevant to your consideration on whether or not to approve additional wells. And those are the only enumerated factors. And so when you look at each of these considerations for why you would approve a drilling unit or why you would authorize additional wells, you see that these all involve technical downhole characteristics of the reservoir. It involves a downhole evaluation of geologic and engineering evidence. And we think about the evidence that you routinely see before you when you approve drilling and spacing units or additional wells. You see ISOPAC maps, you see structure maps, you see cross sections from the geologist establishing that that the formations are present and that they'll be productive. And then from the engineering perspective, you receive volumetrics, you receive drainage information, economics, and decline curves showing that we're not going to be draining outside of the unit boundaries, that we are proposing the correct number of wells, and that those wells are going to be economic. And then you do receive some land testimony. It is almost always summary testimony that establishes that the applicant is an owner with the right to drill somewhere within those lands. That's typically all you see from a land perspective. You're not usually given information regarding the surface location at all. You're never given information regarding setbacks from a surface location to a building unit. That's information you get during the Form 2A process. You're never given information regarding sensitive wildlife habitats, truck routes, other mitigation measures. Again, that's information that comes in during the 2A process. again, from a land perspective, ownership is the only issue you really consider. And I think when you look at the evidence that you routinely see before you, it supports the notion under the Act that the only things that you really need to consider are prevention of waste and protection of correlative rights. Turning to 8 North's case in chief today, you will see that we have met our burden and that you can establish the 2,720 acre unit and then approve the additional wells that are requested in both units. We'll be presenting evidence, first of all, that we, 8 North, is an owner with the right to drill in these application lands, and therefore we have the right to request the relief that's come before you today. We have our landman here, Mr. Rayburn, that will testify as to 8 North's working interest ownership in each of the units. He will testify the basis for his opinion. It involves evaluation of leases and lease records, as well as looking at those leases and lease documents consistent with title information. That's something that landmen do as part of their job. It is routinely part of their job to evaluate title opinions, evaluate lease records, and determine ownership before they bring these applications before you. And I'll have to say that the issue of ownership has actually not been challenged. There's no motion to dismiss these applications based on 8 North's lack of standing. So while we had this motion in limine that we just discussed, that there's no motion to dismiss these applications based on the allegation that 8 North is not an owner, but you will receive evidence and testimony to that effect. You'll also receive evidence and testimony that the geologic formations are present throughout the entirety of the application lands, that the Codell and Niobrara formations are present and constitute a common source of supply. Therefore, they'll be productive formations for purposes of development. And then finally, you'll receive evidence that the 2,720 acre unit is not smaller than the maximum area that can be drained by one well, and that the total number of wells requested in both units are necessary to efficiently and economically develop the resource, prevent waste, and protect correlative rights. So we believe that we will meet our burden today and that you can approve these units. That being said, we do anticipate a decent amount of testimony today on surface. That's been primarily Boulder County's issue that they've raised in their protest and throughout their pleadings. And so while we don't believe that that's relevant to your determination, we are going to be offering you some evidence regarding 8 North's planned surface locations. We're doing that in an effort to be transparent and in an effort to alleviate some of the concerns that were raised this morning by the public and also by the local governments. In fact, as Mr. Rouse summarized, I think it's because 8 North came forward and provided some of this evidence as early as it possibly could that Longmont felt it was able to withdraw its protest in the blue paintbrush matters to the north, and that Lafayette and 8 North reached an agreement whereby Lafayette basically is standing down on its case in chief in the lupine matter. And what you'll see from our evidence is that the planned surface locations in both the blue paintbrush and the lupine unit are wholly outside of Boulder County. Therefore, Boulder County will not have jurisdiction over those, the local permitting process, and is not the relevant local government over those locations. In the blue paintbrush unit to the north, the planned location lies entirely within Weld County. And then in the lupine unit to the south, the planned location lies entirely within the town of Erie. You'll also receive evidence that those locations are have been planned and proposed in a manner that will minimize impacts to the surface and to the public. Boulder County has identified a number of specific surface areas of concern, and those planned locations lie anywhere between about 4,000 feet to over 10,000 feet from those areas of concern. So we really feel that these planned locations, when you do get to the time of the 2A process, are very much in line with minimizing impacts to the surface. And finally, 8 North's evidence will show that these locations are not near sensitive wildlife habitats. So again, we're going to be offering you that evidence, but as you evaluate all of the evidence before you today, I'd ask that you keep in mind the central questions that are really relevant to your decision on whether or not to approve a drilling unit and establish additional wells. And that is whether the drilling unit and the additional wells will prevent waste and protect correlative rights. And we believe that you will receive ample evidence to answer those questions in the affirmative and approve 8 North's applications. So with that, thank you very much.
Commissioners.
Mr. Chair, I just want to make sure the record reflects that Dr. Wolk joined us at 10:33.
Thank you. I had 10:35.
34.
move on? All right, shall we move on?
Thank you. Commissioner Kate Burke again on behalf of Boulder County. We will be presenting some public health and safety and surface concern evidence today. And I just want to point out that our protests initially got dismissed, because we failed to present specific enough public health and safety issues. At that point, we had no inkling what the surface locations were supposed to be. And so I'm just pointing out that in your rules, a local government is required to list out their public health and safety concerns in their protest or intervention at a stage when the applicant is not required to give any surface information. And then we were dismissed for failure to do that adequately. But now we're told that you can't consider that information anyway. So for you to consider, there is a problem with your rules. I also want to point out that as Ms. Fulcher was saying, Boulder County will now, I don't know what part we will or will not play in the Form 2 and 2A process, as no longer being the jurisdiction in which the wells are cited. However, the evidence will shows that the impacts will nonetheless affect the county and its residents. And so that's why our information is relevant, arguably required by your own rules, and important. And then I do have a legal argument. This only applies to the document ending, or the docket ending in 695. That's the spacing unit application in the blue paintbrush northern unit, which has to do with the statutory standards for establishing a unit. And I just want to bring out 346116 sub 2, which are the two things that you are supposed to determine upon evidence at a hearing. One of them is the existence of a common source of supply. And the other one is, the most important one here, is the appropriate acreage to be embraced in the unit. Okay, and the way, the background for that is, as Ms. Fulcher pointed out, to prevent waste, avoid drilling unnecessary wells, and protect correlative rights. But nonetheless, you have to determine the appropriate acreage. And there are several reasons why the rules and the statutes leave you without sufficient criteria to do that. First of all, this is amplified by Senate Bill 18230 that was recently enacted and came into effect on July 1st, which now says that any drilling and spacing order can authorize any number of wells. So it's no longer limited to one well and the area that would be drained by the one well. As far as the common source of supply, we're talking about the Niobrara and Codell formations. And I'm no expert, but I understand that they extend for thousands and thousands of square miles. One thing I read says even into Canada. So we're talking about a massive source of supply that cannot be appropriately tied into a specific set of acreage. And then finally, there's no threshold amount of mineral interest required either. So essentially, an operator who owns anything can draw any shape unit they please over the Niobrara and Codell formations and ask for whatever number of wells they think appropriate. And you have no way to say whether that's the appropriate acreage to be embraced or not. As I, again, understand the evidence, we'll see, but I think what the evidence is going to show you is that the way the unit gets determined is we own acreage in this general vicinity. So therefore, we think about 4 square miles would work. And then the engineers and the geologists say, well, because of the way the Niobrara and the Codell are laid down there, about 32 wells ought to deal with your 4 square miles. So the size of the unit and the number of wells, it's a circular reference. How many wells for this unit? 32. How big a unit for 32 wells? 4 square miles, the end. And so again, there's no objective criteria by which another party can evaluate the appropriateness of that. And it is serious because it's only after establishment of that unit that the operator, of course, can involuntarily pool a bunch of other mineral owners. So there's significant rights associated with the creation of these units, which at this point is untethered from anything other than the operator's own convenience. And then I had some cites about how important it is to have standards for administrative agency action. It's a due process problem. It also underlays arguments about arbitrary and capricious decisions. And so just very quickly, I think you have it, but State Farm Mutual Auto Insurance Company, 788 P. 2nd 808. Due process is violated when a local government or an administrative agency makes a decision in the absence of sufficient standards. Similar is the Moya case, 870 P. 2nd 620. And then the Farmer versus Colorado Parks and Wildlife Commission, 2016 COA 120. Quote, everyone would agree that an administrative agency cannot validly engage in quasi-judicial decision-making without sufficient standards. So we think this is an important issue to look at. The way the statute is written, you're left without sufficient standards for those decisions. So we are asking, and just to counter one point that Ms. Fulcher said, she said the issue of ownership is not disputed. We don't have specific evidence to dispute that they're not owners. However, we will be making an argument that the application should not be granted for failure of sufficient evidence to that point.
Thank you.
May I ask a question?
Certainly, Commissioner Overturk.
With regard to the legal argument that you put forward about the lack of sufficient standards in the statute, I know you know this, but some other people don't, that we don't actually write the statutes, that the legislature does that. And so isn't that really an argument that the statute itself is insufficient or void for vagueness? In other words, something that's beyond this commission's ability to determine?
Yes, so let me just grab which case I want to mention here. Yes, and we're not suggesting that you can change what the statute says, but what we're saying is the way the statute's written, and especially now as amended, you can't go forward and do your job to determine the appropriate acreage. And where what it falls under, technically speaking, is what's called the non-delegation doctrine. And the more recent case, well, it's not recent, but the Colorado Supreme Court case on that is Cottrell versus City and County of Denver, 636 P. 2nd 703. And what that says is basically the legislature can't delegate the power to an administrative agency unless the legislature provides sufficient standards. And so it's not your fault, so to speak, but in the circumstance where the legislature hasn't done that appropriately, you can't really go forward and make a rational, non-arbitrary decision.
And how do you, there are other provisions within that same statute that say that the commission is authorized to divide any pool into zones and establish drilling units for each zone. Doesn't that necessarily give the commission the authority to split up these larger formations into appropriate zones?
Yes, and I don't dispute that, and I don't dispute that 8 North has to develop the entire Niobrara. It's just that there's no reason for it to be 4 square miles in the certain area it is versus 3.5 versus 2 somewhere else versus 20 somewhere else. So we need some criteria by which those, I'm not sure how the zone procedure works or what that means exactly, but as far as the drilling and spacing units, we don't dispute that you create those and that they have some value, but they need to be tied to something that makes some logical sense.
Thank you.
This actually is a question for, I believe, for Mr. Davenport. You cited the Senate Bill 18-230. Said any number of wells. Were these applications made before that passed, and would that have any bearing on this particular matter?
These applications, my recollection, were submitted both before the Senate Bill 18-230 was passed and before it was made effective pursuant to its terms. So it was made effective as of July 1, 2018, as to all conduct which occurs on or after that date. And so I do not believe that the new version of that statute would apply to these applications here today.
Okay. All right. I have other questions, but I think they can wait. Anyone else? Hearing nothing, I guess we'll move on to the case in chief.
Thank you, Mr. Chair. If you could just give our witness one moment to get set up. Does that mic work? Do you want to switch places? So you're going this work? Okay. Oh.
Common sources.
We don't want that one. Mike. Okay. All right. Thank you. I think we're ready here. All right. Our first witness is Mr. Rayburn. Mr. Rayburn, if you could introduce yourself to the commissioners and describe your position with 8 North.
Good morning, commissioners. My name is Jason Rayburn. I'm the staff landman for 8 North. I've got 12 years experience as a landman and 8 years working the DJ Basin.
Thank you, Mr. Rayburn.
Hold on. We need to swear your witnesses.
Thank you, Mr. Chair.
Would you like to do all of them together at once, please?
You can probably sit. Okay.
All right, hold on. I've got 2 gentlemen standing in the back and 3 in the front. It's everybody?
That's correct. The 2 gentlemen in the back have been called as rebuttal witnesses.
Okay. Well, just to organize, let's start in the back and work our way around up to the front. And just in turn, I'd like each of you to raise your hand and say your name and then say that you swear to tell the truth. And you can just all go in succession, starting with the gentleman on my left there in the back.
My name is Blank.
You're good. Thank you.
Christopher Simmons. I swear to tell the truth.
Jim Folsick, I swear to tell the truth.
Neil Duncombe. I swear to tell the truth.
Jason Rayburn, I swear to tell the truth.
Thank you.
Thank you, gentlemen.
Thank you very much. All right, Mr. Rayburn, as part of your job as a landman, have you reviewed 8 North's records of its leases and assignments in the application lands at issue in the blue paintbrush unit?
Yes.
And did that review cover hundreds of documents and voluminous writings?
Yes.
Have you been able to determine 8 North's ownership interest in the application lands from these documents?
Yes.
And is this the process that you use in your regular course of business for determining ownership?
Yes, it is.
And is your review corroborated by preliminary title information?
Yes.
And did you personally prepare or directly supervise the preparation of Exhibit 1 that's before you now?
Yes.
And does this exhibit summarize 8 North's working interest in the application lands?
It does.
All right, thank you very much. If you could, I want you to explain this exhibit to the commissioners.
The yellow indicates 8 North's leasehold, which a portion of lies in the southwest quarter of Section 18, which is Weld County, and the balance in Boulder County. The green star denotes 8 North's planned surface location.
And what is 8 North's approximate working interest in these lands?
54%.
And you noted that the star that we see on Exhibit 1 indicates 8 North's planned surface location. Do you have a surface use agreement covering that location?
Yes.
And approximately how long did it take 8 North to secure that surface use agreement?
A little over a year.
And was that time also spent evaluating that surface location and other locations?
We did evaluate other surface locations.
Let's move then to Exhibit 4. If you could describe this exhibit to the commissioners.
This shows 8 North's planned horizontal wells, the productive portion of those horizontal wells as they would lay out in the spacing unit. It also shows our planned pipeline for oil, gas, and water in red that leads from the surface location, the green star, heading east.
And it appears when I look at this map that a portion of your wells or all of your wells will extend east into Section 18. Does 8 North intend to backbuild to locate into that portion of the unit?
Yes.
So these wells will develop the entirety of the application lands?
Correct.
And you said that the red dashed line illustrates the pipeline that 8 North intends to build to the location?
Yes.
And do you plan to use that pipeline for oil, gas, and water?
Yes.
So with respect to that pipeline, 8 North does not intend to flare any of its produced gas from this unit?
Correct.
Okay. Mr. Rayburn, are you familiar with the protest that was filed by Boulder County in these matters?
I am.
And in its protest, does Boulder County raise or identify a number of specific surface areas of concern in these lands?
They do.
Okay, well, let's turn then to Exhibit 3. This is the Commission's Bates number 398. If you could describe the surface area of concern that this exhibit depicts.
Boulder cites the Dry Creek, which runs along the northern border of the proposed spacing unit. The exhibit also shows from our planned surface location, the Dry Creek is more than 4,000 feet.
This exhibit also appears to be an aerial photo of the application lands, is that correct?
Yes.
And would you describe this as a rural part of Boulder County?
I would.
Do you know the approximate population density in the application lands here?
I believe it's 15 people per square mile.
And where is that information obtained from?
We reviewed Boulder's exhibits and we obtained the information from that.
Let's turn then to Exhibit 5. This is Bates Stamp 400. If you could describe this exhibit to the Commission.
Excuse me, in addition to the spacing outline and the planned surface location, the red circle indicates a sensitive wildlife habitat for the bald eagle. Go ahead.
No, that's fine. And where was this information? How was this information obtained, Mr. Rayburn?
From the Colorado Oil and Gas Commission website, which the data from there is pulled from Colorado Parks and Wildlife.
And what's the approximate distance between this nearest sensitive wildlife habitat and your planned location?
This is also over 4,000 feet.
All right, thank you. Sticking with the specific areas of concern cited by Boulder County, if you could describe Exhibit 6 to the Commissioners.
This shows the riparian lands within the proposed spacing unit, running from the northeast corner headed west.
And where was the information on this exhibit obtained?
From the Colorado Natural Heritage Program website and under their wetlands information section.
And is 8 North's planned location near a wetland?
No.
All right, let's turn then to Exhibit 28. This is Bates stamped 371. If you could describe this exhibit to the Commissioners.
This exhibit shows the sunflower farm's proximity to our planned surface location being over 9,800 feet.
And what exactly is Sunflower Farms? Just for the Commissioner's clarification.
I believe that was a specific location of concern brought up by Longmont and Boulder counties.
And is it a farm? Is it preschool? Things of that nature?
I believe it's a school.
Okay. You mentioned City of Longmont. Was Longmont a previous protestant in docket 774?
Yes, they were.
And what was Longmont's chief concern raised in its protest?
They have a planned location for a school in the future. And that planned location is noted by the red dash box, which is in the northwest corner of our proposed spacing unit. And as you can see, it's over 10,000 feet from our proposed surface location.
And did Longmont withdraw its protest as a result of your planned location?
They did.
Okay. Let's move to Exhibit 10. It's Bates Stamp 405 in the Commissioner's packet. If you could describe this exhibit for the Commissioners, please.
This shows our planned traffic route from our planned surface location highlighted by the yellow dash line.
And does any portion of that traffic route go through Boulder County?
No, it's fully contained within Weld County.
Okay, thank you very much, Mr. Rayburn. We're going to turn now to our land exhibits that were filed for docket 773. So these land exhibits are in relation to the lupine unit. All of the exhibits before you previously were for the blue paintbrush. So turning to 773. Oh, excuse me.
Sorry.
Apologies, we're being really economic today and sharing electronics. So turning to the exhibits in 773. I want to first ask you the same questions. Have you reviewed 8 North's records of leases and assignments with respect to these application lands, 35 and 36?
I have.
And did that review cover hundreds of documents and voluminous writings?
Yes.
And based on that review, have you been able to determine 8 North's ownership interest in these application lands?
Yes.
Is this also the process you use in the normal course of business?
It is.
And has your review been corroborated by preliminary title information prepared by a title attorney?
Yes.
Did you personally prepare the exhibit that we see before us today, Exhibit 1?
I did.
And does this exhibit summarize 8 North's working interest in these application lands?
Yes, it does.
Okay, if you could, then explain this exhibit to us, beginning with 8 North's working interest.
8 North's working interest is 70% within the two sections, 35 and 36, which are the loop-in spacing unit outline. It also shows our planned surface location with the green star. The green dash line shows the boundaries between the 3 counties, Boulder, Weld, and Broomfield to the southeast.
And you mentioned that the star indicates the planned surface location. Do you have an executed surface use agreement covering that planned surface location?
We do.
All right, moving then to Exhibit 2, Bait Stamp 699. If you could describe this exhibit to the commissioners, please.
This exhibit shows our 8 North's planned productive portion of the horizontal wells requested in the spacing applications.
And does 8 North plan to drill all of the proposed wells from the location that's denoted by the star?
Yes.
All right, let's move to Exhibit 3. If you could describe the municipal boundaries that are within the application lands for the commissioners?
This shows Lafayette and Erie municipalities fall within the space unit outline.
And does the planned location, or which municipality is the planned location located?
Within Erie.
And are you familiar with the protest that was filed by Lafayette and by Boulder County?
Yes.
And with respect to the pre-hearing statement that was filed jointly by those local governments, did the local governments list specific areas of surface concerns within the application lands?
Yes, they did.
And are those listed on Exhibit 25 that's before the commission now?
They are.
So let's move very quickly, recognizing the stipulation that was entered with Lafayette in discussing the proximity of your planned location to these locations. Let's start with Exhibit 5. If you could describe this exhibit to the commissioners.
This shows the Great Dog Park being more than 4,000 feet from our planned surface location.
And then moving to Exhibit 6.
The closest Lafayette residential area, being Josephine Commons, is over 5,500 feet from our planned surface location.
So over a mile from the planned surface location?
Yes.
Okay. Exhibit 7.
This is the Pioneer Elementary School location being more than 8,300 feet from our planned surface location.
And would this be the nearest school to your planned surface location?
Yes.
Okay. Move to next Exhibit 8.
This shows the Bob L. Berger Recreation Center being more than 9,000 feet from our planned surface location.
And then finally,
the Lafayette Cemetery being more than 9,100 feet from our planned surface location.
so of each of the specific surface areas of concern raised by Boulder County and Lafayette, you're within 4,000 to 9,000 plus feet of your planned surface location?
Correct.
All right, thank you. Let's move to Exhibit 11. If you could describe this exhibit to the commissioners, please.
This exhibit shows the distance from our planned surface location to the nearest sensitive wildlife habitat, identified as also the bald eagle nest, being more than 4 miles away from our planned surface location.
And from where was the information obtained that's depicted on this exhibit?
This is also from the Colorado Oil and Gas Commission website.
And is that information taken from Colorado Parks and Wildlife?
Correct.
Okay. Let's turn then to Exhibit 12, if we could. Describe this exhibit to the commissioners, please.
This shows our planned traffic route from the planned surface location, highlighted by the red dashed line.
And does any portion of that planned traffic route lie within Boulder County?
Yes, there is a portion from the surface location heading south to County Road 7 and then heads east.
So the balance of the road is not within Boulder County?
Correct.
Okay. Just a few additional questions, Mr. Rayburn, that pertain to both the blue paintbrush unit and the lupine unit. First of all, I guess, is the information that you've provided here today with respect to the surface locations typically provided when you testify in horizontal spacing and density applications?
Not to this degree.
Okay. And are you aware of any public outreach efforts that 8 North has made with respect to any of the local governments that have raised concerns or protests within any of these applications throughout the entirety of the year that they've been pending with the commission?
Yes, we've had face-to-face meetings, telephone calls, or telephone meetings with the municipalities and also Boulder County. Most recently last week, a phone call meeting with Lafayette, and I think there's a planned meeting for Boulder next week.
Was there also a telephone meeting with representatives of Boulder County, I believe last Tuesday?
Yes.
All right, thank you very much. One final question, Mr. Rayburn, were these land exhibits created under your direction and control?
Yes, they were.
And are they true and accurate?
Yes.
All right, I would ask that they be admitted into the record. And that concludes my initial questions for Mr. Rayburn.
Please, if they have you have an opportunity for cross-examination.
Mr. Rayburn, my name is David Hughes. I'm a deputy county attorney with Boulder County, and I'm one of the attorneys representing Boulder County in this matter. When someone sells their mineral interest, that transaction is reflected in a deed?
Yes. The conveyance is reflected, but not the actual contract typically.
A deed showing mineral interest is a key document in determining mineral ownership.
Yes.
And people who own mineral interests can lease those interests.
That is correct.
And that agreement is reflected in a lease?
That their ownership is leased, correct.
So a mineral lease is a key document in determining mineral ownership?
Yes, it is.
And a leasee can assign its interest in a lease to another leasee?
Under most circumstances, yes.
Okay. And that transfer is accomplished through a written assignment?
Correct, filed in the county records.
So an assignment of a lease may be another key document in determining mineral ownership?
Not necessarily, no.
Is an assignment of a lease ever a key document in mineral ownership?
The assignment that is filed for the lease is between either the original lessee or future lessees, but it's not between the mineral owner unless the mineral owner is the lessee.
Well, an owner of a mineral interest is considered an owner for purposes of COGCC rules, isn't it?
I think under a different context.
So an oil and gas lease can expire under certain circumstances, right?
Yes.
If a lease expires, then the right to develop the minerals reverts back to the mineral owner?
Typically, yes, that is how the lease operates.
And a lease could expire if the lessee fails to develop the minerals under the lease within a certain time frame, for example?
It could be for a number of different reasons, but that could be a reason depending on what your lease says.
Okay. And a lease could expire based on a lapse in production?
Again, depending on the terms of your lease. If that is a term, then yes, it could expire under those situations.
Now, you've seen disputes between companies about which company owns certain mineral rights.
I have.
And when those disputes arise, companies rely on the types of documents I asked you about to prove the right to drill or ownership, deeds transferring mineral interests, leases, assignments, things like that.
Yes, amongst other things.
Now, I want to ask you more specifically about your testimony today. You're testifying regarding docket number 171-000-695, 773, and 774. Is that correct?
Yes.
Are you aware of any errors or omissions in the application materials for those dockets?
None that I'm aware of.
I'd like to ask you about Exhibit 1 and combined dockets 695 and 774. Exhibit 1 is the only document that 8 North is presenting as evidence today to demonstrate it is an owner with a right to drill in the application lands, correct?
Yes.
And did you personally prepare Exhibit 1?
I did.
8 North has a 54% working interest in the proposed spacing unit. Is that correct?
Right.
And you've determined 8 North has the right to drill through leases or outright ownership 54% of the minerals in the proposed area?
We do have the right to produce the leases that we have in the spacing unit.
In 54% of the area?
That is part of the reason we're here today, is to seek approval for us to operate the entire unit.
Right, but your Exhibit 1 there says 8 North spacing unit working interest 54%. Is that correct?
Yes.
Okay, and what does the 54% mean?
That notes how much working interest or leasehold we have within the spacing unit.
So are you asserting that you have a right to drill in that 54% currently?
We have the right to develop the acreage within the spacing unit.
All of the acreage?
Again, that's part of our application here today, is to establish a spacing unit in order to develop those boundaries that we've requested.
Right, and my question is, in the absence of a spacing unit, are you entitled to develop only 54% of those interests?
In absence of a spacing unit, depending on the rules that the commission establishes for spacing units, that is how we determine what we are able to develop. That does not necessarily mean we are limited to the 54% that's noted there.
So as of today, you are asserting that you are entitled to develop 54% of the interests in the unit for 774 and 695.
I'm asserting that we have 54% leasehold within the spacing unit.
The areas in dark yellow on the map are the areas where 8 North has leaseholds.
I'm sorry, could you repeat that?
The areas in dark yellow on the map are the areas where 8 North has leaseholds?
Correct.
Now, in reaching the conclusion that 8 North has a 54% working interest, you relied on a preliminary ownership report?
Correct. In addition to title opinions and also an examination of our internal records.
Okay. Did you prepare the preliminary ownership report?
No, the broker that I contracted to research the records in the county came to the conclusion, and I reviewed. If there are any issues with that, then those are worked out. But their determination, in addition to the other items that I mentioned, have led to the conclusion of the 54% working interest.
Okay, and in addition to the preliminary ownership report, you mentioned title opinions?
Title opinions and also our internal land record system.
Okay, and how long is a preliminary ownership report?
The length of the report varies. It depends on how many owners have historically been in the chain of title from patent to present. It depends on the size of the area.
Let me clarify my question. I'm asking you how long the preliminary ownership report is for this particular docket.
I don't have that information.
You didn't bring the preliminary ownership report with you?
I did not.
Does the preliminary ownership report summarize the underlying chain of title documents that 8 North is relying on today?
It does.
Okay. Have you reviewed all of the chain of title documents referred to in the preliminary ownership report?
I have reviewed the reports.
Okay, but not the chain of title documents themselves?
I did not review the chain of title, no. The reason for that is the brokers that I utilize are experienced in running title and determining ownership. There were no flags from their ownership report that needed further investigation on my part.
Okay, so you essentially relied on the title reports, the preliminary ownership reports prepared by others.
That is correct.
Okay, and your testimony today about 8 North's ownership interest is based on the information that you reviewed from those other individuals.
Correct.
Now, 8 North has not provided any title opinions to the COGCC, is that correct?
That is correct.
And it has not provided a preliminary ownership report to the COGCC, is that correct?
That is correct.
And are you prepared to produce the preliminary ownership report today?
No.
Is that because you believe that information is confidential or privileged?
Yes.
Looks like counsel is talking to the witness. Is that accurate? Okay, I just want to make sure. How many of the documents in the chain of title did you personally examine?
None.
Now, going back to Exhibit 1 for 695 and 774, it looks like that 8 North has no leasehold interest in Section 23. Is that correct?
That is not correct. If you look closely, you'll see there is a small strip of acreage that runs along the north half of the northeast corner. That is a, thank you. That is a lease that is part of another lease in Section 14, a meets and bounds description, if you will. So it doesn't conform to the governmental quarter section. And so we do have leasehold in Section 23.
Okay, so that tiny fraction in the northern portion of Section 23 is all of the ownership interest that 8 North has in that section. Is that correct?
That's correct.
Okay. So for the remainder of Section 23, 8 North would need to obtain the right to drill there either through leases or pooling?
I'm sorry, you said we have not yet obtained the right to?
I said if you wanted to drill there, you would need to either obtain the right to drill through leases or pooling.
Correct.
And pooling can include.
We also obtain the right to drill through permits.
Pooling can include forced pooling. Is that correct?
Statutory pooling is a mechanism that is available.
Okay, and you're using statutory pooling interchangeably with the term forced pooling?
Correct.
And Boulder County owns the majority of the mineral interests in Section 23, right?
No.
Did you look to see who owns the majority of the mineral interests in Section 23?
Yes.
Okay. Boulder County owns many of those mineral interests, is that correct?
Boulder County does own mineral interests in Section 23, yes.
Okay. Is 8 North going to pool Boulder County's mineral interests if the unit and density application is approved?
We will have a discussion with Boulder County in an attempt to lease their acreage.
And if you're not able to obtain a lease, you would force pool the county?
If we are not able to obtain a lease and another party is not able to obtain a lease, then statutory pooling proceedings may be necessary.
Okay, I'd like to ask you about Exhibit 1 for docket number 773. Now, Exhibit 1 is the only document that 8 North is presenting as evidence today to demonstrate it is an owner with a right to drill in the application lands.
That's correct.
Okay. And as with the other docket, in preparing, I assume you prepared Exhibit 1 for 773 as well?
Yes, I did.
Okay. And you relied on, in part, on a preliminary ownership report?
Along with title opinions and our internal land systems.
Okay. And did you prepare the preliminary ownership report?
No.
Did you prepare the title opinions?
No.
Did you review any of the documents in the chain of title?
No, I did not.
How many documents are there in the chain of title?
I don't have that information with me today.
Now, according to Exhibit 1, there's a 8 North has a 70% working interest in this unit.
Correct.
Did you bring any of the documents that you were relying on in support of Exhibit 1 today?
No, I did not.
Did 8 North provide any chain of title documents such as mineral deeds, leases, or assignments to the COGCC related to its ownership interests?
We did not provide that to the commission today.
Okay. And that is for both docket number 773 and the docket numbers ending in 695 and 774. Is that correct?
That's correct.
Okay. Now, last night, 8 North sent the county some chain of title information on dockets numbers 695, 774, and 773. Is that correct?
Yes.
Okay. And for 695 and 774, that was 7 documents?
I was actually not on the email, so I'm not exactly sure what documents were contained there.
Okay, so you were not involved in reviewing the documents that were sent to Boulder County?
These are leases that Extraction, or I'm sorry, 8 North is a lessee or an owner that the attorneys sent over to you, and the assignments vesting 8 North with that interest.
So are you able to personally testify about those documents today?
Which documents specifically?
The documents that 8 North sent Boulder County last night.
I'm gonna have to object to that. Sorry to interrupt. It's outside the scope of direct, and it also assumes a number of documents that are not in evidence anywhere.
I'm sorry, would you repeat the question, please? It was asked.
I asked whether the witness was able to testify as to the documents that were sent to Boulder County last night via email by 8 North.
I'm familiar that those.
Oh, wait, you don't have to answer yet.
So the witness did not testify about any specific documents. There was no testimony about any documents that were sent to the county. The only discussion of those documents was during the preliminary evidentiary legal arguments. So the witness doesn't have any testimony on the record concerning these documents. Therefore, it's outside the scope of his testimony to be cross-examined about those documents. It also assumes facts that are not in the record. So the documents to which Boulder County is referring are not in the record anywhere. They've not been provided by Boulder County to the commission. They've not been provided by 8 North to the commission. So the fact that they've been provided to the county is a fact that has not been proven by the county. And so the assumption that they've been provided to the county can't be relied upon in asking the question.
And what's the purpose of the question?
Oh, the purpose of the question is to follow up on the information presented in the opening statement, indicating that Boulder County did have an opportunity to review some title information. I'm trying to assess whether the county actually did have that opportunity. So it goes to the ownership question, which is the essential issue that the county has raised from the beginning of this case.
Thank you. Sorry, not being an attorney, I sometimes need to ask my attorney and get some help for that. I think I will sustain the objection on this.
I have no further questions.
Thank you. Ms. Prine, how much time does Boulder have left at this point?
35 minutes.
All right. Ms. Fulcher.
Mr. Chair,
Yes.
unless the commissioners have questions of Mr. Rayburn, I just have a few questions on redirect for Mr. Rayburn. So I'll leave it to you.
I think if you want to do the redirect, then we'll go to commissioner questions.
All right, thank you very much. I'm going to move back to 8 North's Exhibit 1 in dockets 695 and 774. Mr. Rayburn, you testified that Boulder County does have some mineral ownership in Section 23. Is that correct?
Yes.
And based on your review of the ownership reports and title, are there other owners within Section 23 that own minerals?
There are other owners in Section 23.
In particular, could you describe who owns the north half, or excuse me, the south half of Section 23, based on your review of the ownership records?
Anadarko Land Corporation owns the minerals there, which have been leased to Kerr-McGee.
And was Anadarko, or were Anadarko and Kerr-McGee notified of these applications?
Yes, they were.
And have they filed protests of either of these applications in these dockets?
No, they've filed a 510 letter of support.
In support of these dockets?
Correct.
Okay. And you mentioned that you did not provide ownership reports to the commission. Is that correct?
No, we did not provide any ownership.
And what about title information? Did you provide that to the commission?
No title information was provided to the commission.
And is that information privileged and confidential?
Yes.
And you said that you did not review all of the deeds, mineral deeds and other documents in your title reports. Is that correct?
Yes.
Okay. But did you review the underlying leases and assignments as part of those title reports?
Yes.
Okay. Let's turn to, Exhibit 1. And this is for the lupine unit, docket 773. Again, with respect to the portion we don't see shaded here, it would be the west half of Section 35, based on your preliminary, or based on your title information and your ownership reports. Who owns the balance of the interest in this part?
Kerr-McGee.
And were they notified of this application?
Yes, they were.
And did they protest this application?
No, they did not.
All right. Thank you very much. I don't have any further questions for Mr. Rayburn, but of course, if the commissioners have questions, he will sit up here for you.
Very well. Commissioners, any questions? Yes, Commissioner Yeager.
Mr. Rayburn, you said that the discussion you had and some of the slides you presented on the potential surface issues, that's not something that is generally looked at this stage. Can you describe what process you do go through from a very preliminary, in a very preliminary way, how you look at potential surface issues when you're establishing requests for pooling applications or spacing units?
Even though that is simply outside the scope of the spacing application process, and I also will clarify, I'm not the surface landman for either application. We have a separate group for that. We consider locations within the spacing unit and also locations that are adjacent. In addition to that, we look to those owners that we have established relationships with, surface owners, and that can be crucial in our examination.
Sure. And so the potential impacts or some of the things you showed, like the eagles and the school, the parks, those were all raised by Boulder County, right? Not identified by you.
The school and the other points for docket in 773, those points were brought up by the city of Lafayette. And I believe the sensitive wildlife were pointed out in Boulder's protests.
That's not something you would go through at this stage of planning.
Correct. Those are all surface related.
Right. And how about the access roads, truck traffic? Do you look at that in detail?
that is typically not part of these proceedings for spacing applications.
Okay, thanks.
Commissioners, any other questions? Commissioner Hawkins?
Is there, from your land perspective, is there a reason why you have a 1,280 acre unit proposed in Township 1 North and a 2,720 acre spacing unit in 2 North?
Well, in addition to the geologic and engineering testimony you'll hear, surface locations are part of a consideration when we are determining the best way to develop our acreage and our leases. And the surface location, as you know, is a struggle for all operators in the basin. For the blue paintbrush unit, we were able to secure a surface use agreement large enough that would allow us to develop the full 2,720 acre acreage that we've requested in the applications.
Would it have been any different if you had made 2 smaller units there could you develop that from a single surface unit or surface location, I mean?
From our examination, there was no other surface viable or available. And so that is one of the driving factors behind the shape of the spacing unit and the size.
Okay, no more questions.
Thank you. Other questions? I have a couple. Just for the record, would you define back build, please?
The back build is a technique used in drilling to, for instance, to go from the starred plan location on the exhibit and bring the wellbore back to this eastern line in order to start your point of production here and go forward.
Thank you. Appreciate that. And this question, or questions plural, is, again, it's outside of the scope of the application, but perhaps you may have done some investigation of this, and it may be another witness that can answer these questions. I'm assuming when you did your traffic route, and Commissioner Ager touched on this briefly, that there was some discussion about length of time that you would be on these pads, number of potential truck trips, those sort of issues, that sort of the impact on the surface with respect to traffic, how long you're going to be there for drilling operations and for completion operations.
I don't have that information, but we do have our rebuttal witnesses here that I think could explain that if you needed more information on trucks and truck traffic.
Well said, Mr. Rayburn. I was going to say the same thing. We've got a couple of witnesses in the back that you've sworn in that can speak to that in a little bit more detail.
And whenever that opportunity arises, would definitely like to have some input on that, please.
Mr. Chair,
Yes, ma'am.
if you would like, we can call them up now since they are sworn. If you'd rather have those answers right now versus waiting for another hour or two in case
What's
that
your
question's
normal
missed.
planned flow here? I don't want to interrupt your flow of your presentation.
I don't think that would be a problem at all if you want to bring those folks up now.
I would like to hear it. What about the rest of the commissioners? Okay,
I have one other question before we leave.
go ahead, Commissioner Hawkins.
Were there any attempts at working an MOU with the county for these drilling and spacing units?
I don't know if that was part of our discussion with them.
All right.
With the county specifically.
All right, thank you.
Okay.
Hello, Commissioners. My name is Blaine Fingelstead, and I work as a regulatory manager with Extraction Oil and Gas.
Mr. Chair, unless our witness is able to remember the extent of your question, would you like to repeat just to make sure He knows exactly what you want to
Certainly,
do.
because it was a bit vague, and I apologize for that. So you laid out some traffic routes that were laid out for this. It seemed a reasonably direct route, and so I'll let you choose whichever one you want to address first. As part of that, and when you consider this, although it's outside of the scope of a spacing application, spacing applications lead to building pads, drilling wells. So I'm curious about when you did that, how much time do you expect to be on these pads specifically for the drilling operations? How long is a drilling rig going to be on location? How long is it going to take to complete the wells on the pad? So how long do you expect to have a frac crew on location? And then during that period of time, roughly an impact on the local traffic in terms of trips per day, large trucks per day, normal vehicles, that sort of thing.
Yeah, thank you. In general, with the construction of these well pads, the drilling completion process takes about a year. One of the things we've been able to do here recently in the last, say, 5 years is push the boundaries on the cycle time for drilling wells. In the past, it's been about 10, maybe 12 days to drill wells that were, say, 1 mile long. And now we're capable of drilling these 2 mile long wells in 2.5 mile long wells, and somewhere between 4 to 5 days. So that's greatly reduced the cycle time on location. And then again, with the completion of the wells, we've also been able to do these wells in batches instead of one-offs. And that's also reduced that cycle time from, say, maybe as much as 10 days per well to about 5 days per well on the completion side. And then given the number of wells in this pad, that with some rounding and some logistical time between drilling completions, it ends up being about a year from breaking ground to first production.
Okay, and for clarification, that 5 days is spud to spud?
Correct.
Okay, and then same with your fracs, 5 days from time you start pumping on one to when you start pumping on the next one, so it includes any movement of equipment or anything like that?
Yeah, so those are on the completion side, it's an average because we don't do them one well at a time. We do them in batches of, say, 4 to 6, and so it allows us to minimize downtime.
Correct. Yeah. Okay, thank you. And what about traffic issues?
Yeah, so on the traffic side, there's typically a handful of oversized loads that are brought in with the earth moving equipment to build and construct the pad. And then there's a handful of oversized loads with the assembly of the drilling rig, the mobilization of that. And then there's ballpark maybe 30 trucks a day, vehicles a day that are not oversized loads during the drilling phase. And then the rest of the truck traffic happens in the completion. And then the other nice thing that we've got here is the commitment to pipelines. That allows us to move those produced fluids off location via pipeline, via truck, or without trucks, so that greatly reduces the amount of impact on local roads.
So for the oversized, when you think about the oversized loads, you have an event when you bring all the equipment in to build the location. When that equipment leaves, moving in the rig, and then the rig's going to be there for 6 to 9 months or something like that, and then again moving it out, and then you move a frac crew in, and the frac crew's there until it finishes completing all the wells, and then the frac crew leaves. So about 6 times where you have a fairly significant impact of large loads going in and out of the location.
Yeah, most of the large loads are in the earth moving equipment, some of the substructures for the rig. Most of the completion work is not an oversized load. It's all fits underneath the DO2 standards there. And then there are just a few potential oversized loads for what we call drilling out and tubing up the wells, preparing them for first production.
Some folks would consider a semi to be a large load.
Well, a garbage truck is not considered an oversized load, nor a school bus or a King Super's truck. So, but they're all fit underneath the DO2 standards, right?
I do understand.
They're not permitted loads.
Yeah, perception is everything. So, thank you. Okay, and then you said roughly 30 normal vehicles in and out over that course of time on a daily basis for that year.
During the drilling phase, we have 30, 40 trucks per day, and that includes like kind of semi-truck to light duty trucks. And then on the completion side, there's more truck traffic because as the sand is brought in from location or from the rail terminals to location, that's where a bulk of the truck traffic happens.
And how, on those that particular route that you have on that, how much increased traffic is on that road? And was there any consideration given for potential road damage, how much that elevates the daily traffic there, safety concerns about impact on residents?
Yeah, so that's one of the things we look for a lot in our surface location considerations is the potential traffic routes. If you'll see on this map here, you can see a lot of ponds and lakes and streams. There's a whole lot of aggregate in this area. It's been a lot of semi-truck traffic for a long time to dig all these gravel pits, and then a lot of them now have filled up with water. And so this area has seen a lot of historical truck traffic on it, and so we will have some temporary truck traffic on there that will be noticeable during the completion phase. But once the completions work is over, the amount of traffic out here will return back to normal and will be virtually unnoticeable from previous.
Okay, so can we go to the same exhibit for 773? And can you speak to that? I mean, other than the fact that it's a fairly direct route, what was the implications for impact on that particular route on the traffic for moving in and out?
I would say the implications here are very similar. In general, we try to get our trucks to a state highway in a relatively direct manner, and then to larger roads so that we can stay off of the smaller city streets, and then and avoid the subdivisions and communities as much as possible.
And what highway is underneath that red line? Is that a state highway?
That's State Highway 7.
Okay. Thank you. I think that's all the questions that I have.
Mr. Chairman?
Yes, Commissioner Holton.
So the designated truck routes is going to be just on Highway 7? Or is there somebody else that's got jurisdiction over some of the roads that you're going to be using?
Yeah, there's a section that's potentially not, so perhaps you'd like to address that.
Yeah. Yeah, that section of road is in the city limits of Erie, and so we will work through their land use application, and the road use will be a part of that.
And about how long is that? Quarter mile, a little over a quarter mile?
Yeah, quarter mile, third of a mile.
Okay. Commissioner Holton, does that help?
A little bit. I know I've got like 60 wells around me, and we've got a road that was within the city limits, which is under our jurisdiction. We had a development agreement with Anadarko to repair that road because it got destroyed in one day. It's not necessarily during the drilling phase, but when they build that pad, it's going to be more than 30 trucks a day. I'll guarantee you that. So I just want to know if there's a development agreement or some kind of a agreement with whoever the entities are that have jurisdiction over the roads you're going to use, that you guys are going to repair those roads?
Yeah, we work with a lot of local governments on road use and road damage and impact fees, and we will work with Erie as part of this development.
But you really don't have anything in paper?
At this point in time, we're currently working with Erie on this surface and truck route and associated impacts.
Well, I would encourage you to do that because probably the biggest impact that you guys have is truck traffic and road damage. And so that's going to be a big deal to the citizens that have to drive through that stuff.
Their heads are going up and down, Commissioner Holton. So we'll take that as a yes, that you recognize that and take his words to heart.
Thank you.
All right. Commissioner Hawkins.
Well, and this is still on that same issue, and that's why I asked the question about the MOU. I know many times operator will have an agreement with the local government that addresses road use and maybe a number of other issues similar that are impacts on the surface. Do you intend to have something of that nature with the town of Erie or with the other, any of the county that would be impacted there?
Yes. So in general, and specifically here for the 773 docket, we're currently working with town of Erie on multiple levels to help mitigate impact, everything from trucks, dust to light and noise. So in most local governments have a land use or oil and gas permit application. And as part of that, we work with them to mitigate similar measures in all of our locations.
Do you need to have anything like that with the county of Boulder?
The land use or the local permit is typically done with the municipality that the surface resides in. So for neither one of these pads would we have an agreement with Boulder County on a surface impacts.
Okay.
What about with Weld County on the other, on 695?
Yeah, on 695, we would be working with Weld County on things from impact to light noise. And there is also, they have a process as well to notify neighbors and mitigate those impacts associated with the development of oil and gas.
And the access there, is that on a county road?
Yeah, sorry, just making sure I got my road numbers correct. Yeah, this docket 695 will travel across private property until it reaches County Road 20 and a half. And then from there, it will make its way back towards the interstate.
So if it's across private property, then is there an agreement? I'm assuming there's an agreement in place of what you're going to do to take care of the road.
Yeah, absolutely. With the surface owners, we have agreements in place with them to build an access road to, and then which will lead us to the county road, Weld County Road 20 and a half.
Okay. Commissioner Olden, any questions about this one since you live in Weld County?
No, as long as they've got some kind of agreement to repair those roads, and that includes Weld County and Erie or CDOT, that's probably the biggest impact that we get in this area is the traffic. And they, like I said, on my road, they beat it up in one day. So it was just gone. So we went back to dirt.
Okay. Any further questions?
I have one more land question that I can ask.
That would, wait. Sorry.
I have a question for the regulatory.
Okay, for the regulatory, Commissioner Ager.
Yeah, just quickly, I think what we're trying to get to here is, and was my original question, is how much planning at this stage, recognizing that surface issues aren't necessarily going into drilling, spacing units, or even density applications. How much, as you move into what we might call a sensitive area, whether it be environmental or public and health and safety related, how much of that planning is going into how you're determining where these what these application lands are? Is there planning related to surface issues? And you don't have to be super specific, but are you looking at potential environmental receptors? Are you looking at public health and safety issues in determining your surface locations as well as those density applications or spacing units?
Yeah, absolutely. So in the initial project scope, we're looking for a lot of factors in the site location. Probably the largest single consideration is setbacks from building units, as well as environmental things, lakes, ditches, streams. And then we take a lot of other considerations into there with the haul routes, local governments, and the everything from like railroad tracks to we've got like a pretty good checklist that we go through to optimize these surface locations. And then we work with the surface owners to find an agreement where we can both maximize the use of the land for ourselves and for them. And then once we've identified these locations, we can look at the mineral development and make sure that it all fits together well. And so here on the blue paintbrush spacing unit, with that surface location, it allowed us to drill 2 to 2.5 mile long wells, which are optimal from us from a depletion and economic standpoint, and fit very well together for the blue paintbrush pad.
Okay, and I'm not sure if you know the answer to this one, just one last one. So once, let's say these permits are approved, what's the likelihood that the surface location changes between now and when you would submit a Form 2 or 2A?
I would say we've worked really long and hard on this location over the last year or so to identify the surface and make agreements with the surface owner and develop a robust plan that involves a lot of mitigation measures from the haul route to pipelines. And I would say that we like this location a lot. And if we can get approved permits from the local government and the state of Colorado, that this location would stay where it's at, and we would develop it from here.
Right, but it could change for whatever circumstances. Yeah. All right, thanks.
One more question for you, and then I think I had a question also for Mr. Rayburn as well, but you get to go first.
I don't need to ask my question. It's already answered earlier.
Okay, all right. Just a bit of an issue around safety, because we talk a lot about safety as well here, and safety for the residents and traffic issues and so on. What sort of program do you put into place for the folks that are going to be driving to and from location, or discussions with your service companies? Because obviously it's someone else is going to be bringing those frac trucks in. Those aren't 8 North frac trucks. Around driver safety, planning ahead, sort of where I'm leading to is that this is a very popular area for cyclists. And they're probably, to say that it's infested would not be too far from the truth.
Yeah, so safety is important to all of us, and especially here at Extraction. So we've got safety in multiple layers with our people, process, and equipment, and the vendor selection. So we do have a strict vendor selection policy where the vendors are required to input training programs and have active training programs. The haul routes are especially important on the traffic, and then we do go through a lot of driver training and considerations with these haul routes, and make sure that we can do the best we can to mitigate the impacts during our development.
Okay, thank you. And did you have a question? Okay, Commissioner Jolly.
Don't need to interrupt. Go ahead.
I'm through.
How big is the surface location?
I believe the maximum stirred acreage is about 17 acres during the drilling and completion phase.
Do you know if that owner is also a mineral owner?
The surface owner is a mineral owner, yes.
Okay. Thank you for your time. I'm not sure if this is probably a question for Mr. Rayburn or for the commissioners. Do we need to put in the record the definition of the word riparian, or do we all know what that means?
That's defined as a role.
We all know riparian.
Okay, all right. Then,
And
no
Mr.
question.
Chair, I believe that it is a defined term in your rules, although we'll double check, but I believe it's included in the 100 series definitions.
Okay, good. Thank you very much.
Crossword puzzle.
There's your crossword puzzle. All right, so.
I think we're ready for our next witness, Mr. Chair.
Well, I'm wondering, it is 5 minutes to 12, and I'm well past my commitment to these commissioners to take a break. So I'm wondering if we should go ahead and break for lunch at this point in time. My recollection, were we going to do an executive session? Okay, so if you would like to start that process, please, and we'll yes. Sorry, Dirk. Reconvene at 1 o'clock, yes. 12:30? All right, so we'll reconvene it. Well, I'm sensitive to these folks who have to go someplace to eat. Half an hour long enough, or would you prefer 45 minutes?
We will be able to find food in a half hour and get back to you if that's your pleasure.
Okay. Okay for Boulder County? All right, so 35 minutes, 12:30.
Commissioners, pursuant to open meetings law, the commission is entitled to enter into executive session at this regular meeting for the purpose of discussing pending or imminent court action with commission counsel and to receive legal advice pursuant to CRS 246402-3A Roman 2. The topics of executive session have been identified on the agenda for some time. We will only be dealing with 2 of these topics in the executive session at lunch. They are to receive legal advice and analysis on the COGCC's permit review process and standing to participate in the process, and then also to receive legal advice and analysis on the district court's order finding plaintiffs have standing and the legal principles of standing in Well, Air, and Water et al. v. COGCC et al. Chairman Benton, I invite you to encourage a motion to enter executive sessions for the matters and purposes I just named.
So encouraged.
Move we go into executive session for the purposes of the AG as just stated.
Okay.
All 3 back.
Second.
Okay, motion made and seconded. Mr. Randall, I presume you'll say aye? Commissioner Randall? Yes.
Aye.
Aye.
We are in executive session.